Permission for moving a motion tomorrow.
Is it very urgent?
Urgent, man.
Okay.
Urgency. Right.
May it please your lordship. Well, from supplementary item number 78 onwards, there is a series of cases for medical admission.
All right.
If your lordship permits me to bring another repetition, same facts, madam. Same facts. I will.
Lordship, I'd like to mention item number 22 to 25. On behalf of the department, I have already informed the council for the additional lordship. Lordship, can we fix it after a week, lordship? Or 2 weeks, lordship?
Your lordship, I appeal for the petitioners. I have no objection to the prayer. If your lordship can kindly fix a date.
Can you give a date?
It's a fag on the lives, your lordship. Retiral benefits are in question. So
Okay,
Yes.
Mr. M. Sharma, on the council for the petitioner. On request made by SMT Tishri, Illinois Standing Council,
Elementary. Lordship.
Elementary Education. When do you want after a week?
After 2 weeks, lordship, a date may kindly fix.
Okay. 13th.
I'm grateful, your lordship.
And lordship, there's the item 69 is a personal pain. Lordship can take it for second, lordship.
After the withdrawal item.
Yes, lordship.
I beg to mention one pending matter, my lord. Grade pay has not been given to the petitioner. He is a lecturer, my lord, assistant professor of technical school, my lord.
Mm.
So matter may come, my lord, to subject to lordship. 8, my lord, 8.
Wait, item 64 of today's list, your lordship. It will be taken up at 2, your lordship.
Huh?
At 2.
60?
4. It is an order matter.
Why do you want it at 2?
Lordship, actually, an NOC was not granted to the petitioner who is willing to participate in the interview, your lordship. Lordship has asked me to take justice service. Justice service is also complete, your lordship. Ultimately, it will become infructuous if it remains pending.
Okay.
May it please for your lordship. Lordship, with respect to item number 70, 72, 73, 74, 75, and 76,
1
we have
minute.
filed our rejoinder affidavit today, lordship. We may be allowed to bring it on record, lordship.
70?
70, 72, 73, 74, 75, and 76, lordship.
Okay.
Obliged.
Similar fare for item number 77. Obliged.
That is the lordship. Lordship, I beg to mention for item number 55, lordship.
Yes.
Lordship, this case was filed for pensionary benefit and the petitioner already got the pensionary benefit. So lordship, matter.
It has become infructuous, your lordship.
The contempt matter.
Yes, your lordship.
Yes, lordship.
MS, you good there?
A. Ahmed,
You appealing on behalf of
MU Mandal.
MS A. Ahmed, Learned Council appealing on behalf of MU Mandal submits that during the pendency of this contempt petition, the petitioner has got his release. And the order passed by this court has been complied.
I appeal for the response number 1, your lordship. A das.
Mr. A. Das, Learned Council appeals for the response number 1.
Lordship, SR Bora for response number
And
5.
Mr. S.R. Bora for the response number 5. Contempt petition is accordingly closed. Yes.
May I please, lordship?
Last year.
I beg to mention item number 80, last item, supplementary list. It is a contempt matter, my lord.
Hmm.
Matter will be adjourned, my lord. Other is also a direction was issued to file affidavit. They have not filed their
Okay, on
affidavit yet.
request made by D. Bora. Learned Council for the petitioner, please after 2 weeks.
My lord.
2 weeks.
Lordship, you kindly fix a date.
You are adjourning the matter, there's no question of fixing.
My lord, let them file affidavit also.
They will find.
Publish.
May it please your lordship.
Oh.
I beg to mention item number 48 to 50, my lord. 48, 49, 50, my lord. Can these matters be taken up on 12th, my lord?
40?
48, 49, and 50.
Okay.
On
On
12th.
request made by Mr.
RM
R.M. Dekal and counsel for the petitioner. Placed on 12th.
12, deeply obliged.
May it please your lordship. Lordship, I beg to mention for listing of a writ petition for motion on Wednesday, lordship.
Witness still not. What is the urgency?
Lordship, the staff of the other staff of the petitioner, the service there provincialized, keeping aside the name of the petitioner. So petitioner is
Then we'll have it after the Diwali.
should be lordship, their appointment is given on Wednesday.
We'll have it on 4th.
Obliged.
May I please, your lordship? Lordship, I beg to mention for listing on IA tomorrow, your lordship. Lordship, I mentioned it on 25th.
Oh.
Your lordship allowed to be listed on Monday, your lordship, today, your lordship. But it is not listed today, your lordship.
What is the IA about?
Lordship, I was suspended from the post of headmaster.
Hmm.
And I challenged that order and this honorable court reinstated me in the post of headmaster, Your Lordship. But respondent authorities, instead of reinstating me in the post of headmaster, I was reinstated in the post of assistant teacher, Your Lordship. But on 20, again, we have challenged that order, Your Lordship, this honorable court, and that petition is pending before this honorable court. But on 23rd of October, I have been given one show cause notice, Your Lordship, directing me to show cause why I have not joined in the post of assistant teacher, Your Lordship. And I have been instructed to show cause within 3 days from receiving the show
Okay,
cause
okay,
notice.
Kumar.
Apology, Your Lordship.
May it please your lordship, praying for listing of the matter, read petition number 7357/2018, your lordship. This petition is for orders use right now, your lordship. May it be fixed on 7th of November,
11th.
11th. Okay, much obliged, your lordship.
May it please your lordship. Lordship, I am praying for listing 2-3 contents matters, my lord. May I pray on 6th, my lord?
13.
I am.
My pleasure, Lordship. Lordship, with the consent of the other side, I beg to mention item number 53, Lordship.
Yes.
Lordship, may kindly adjourn this matter for today, Lordship.
Yeah, 40.
Petitioner, Lordship.
Your good name?
Zedas on behalf of MSB Bhuyan.
On request made on behalf of MSB Bhuyan, General Counsel for the petitioner. When do you want?
After 2 weeks, Lordship.
List the matter after 2 weeks. Obliged.
My pleasure, Lordship. Lordship, I beg to mention item number 8. My senior is annual. Lordship, matter may be listed on Monday, 4th November.
Who's your senior?
YS Mannan.
On request made on behalf of YF Manan, General Counsel for petitioner. List on 4th.
May I please, your Lordship? Lordship, I beg to mention one contempt petition for listing. Lordship, next week, any day
13th.
of that. May I please, Lordship? I beg to mention item number 63.
Yes.
Lordship, pursuant to the last order on dated 30/9/24, we are supposed to file an affidavit affecting dusty service, but the petitioner could not come. Let the matter be fixed on the next week. In the meantime, we will file an affidavit.
Okay, on request made on behalf of Mr. R. Islam. List the matter after 1 week.
1 week.
Yeah.
First of this. My Lordship, I beg to mention for a listing, it's a contempt matter.
Okay. 13th.
May I please, Lordship? Lordship, I beg to mention item number 32 of daily list, Lordship.
Hmm.
On behalf of the engaged counsel, Mr. P. Talugre.
Hmm.
He is unable to come to the court, Lordship.
How about the other counsel in the other with petition? Have you informed him?
Yes, as I have informed to another one.
Okay, on request made on behalf of Mr. P. Talukar, Legal Counsel for the petitioner. When do you want?
After
For the
2 weeks,
petitioner in WBC 2838 of 2023.
Along with
After?
33, both the item together.
Yeah. List the matter
2 weeks, Lordship.
after 2 weeks. Yes.
Obvious, Lordship.
With the concern the other side, I beg to mention item 35. I am appearing for the petitioner, Lordship. That will be adjourned for the day.
Why?
The engaged counsel, Mr. P.K. Sharma is unwell, will not be present today.
You good now?
A. Barbujari.
On request made by A. Barbujari, Legal Counsel. Petitioner, list after?
It will be fixed on
I'm not fixing date here.
just after 2 weeks.
2 weeks. Yes.
May please, Lordship. Lordship, I beg to mention for listing, Lordship, for admission, Lordship.
Yes.
Last posted on 7/2/24, Lordship.
11th.
Obliged, Lordship.
Yeah, please, I prefer listing a contempt petition in the first week of November.
12th.
Lordship, I beg to mention for listing for motion, my lord, one writ petition and another contempt petition. My lord. Writ petition before vacation, my lord.
What is the urgency?
Motion matter. My lord.
What is the urgency in the writ petition?
Urgency is that, my lord, the petitioner's service was not provincial in spite of
Fourth,
court, my lord. And another contempt petition, my lord.
14.
Obvious.
May I please, Lordship? Lordship, I mentioned listing for an writ petition, Lordship. It was last posted in the month of June, Lordship.
Mm.
So Lordship may take up on 8th November, Lordship, kindly.
8 is packed, 12th.
12th November.
Yeah.
Kindly apply, Lordship. Lordship, regarding another matter, item number 65, Lordship.
Mm.
Lordship may take it after 2 weeks, Lordship. The leading counsel is out of station, Lordship.
60.
65.
Who's the council?
A.R. Bhuya.
How much time?
3 weeks.
On request made on behalf of Air Boyan, the council for petitioner. List up to 3 weeks.
Apply, Lordship.
May I please, your lordship, I would like to mention item number 7 and 15, lordship. With passer for the day, lordship, and list after 3 weeks, lordship.
You have item 7 you are appearing for?
Lordship, petitioner, lordship.
Your good name?
Yes, Hussein, lordship, on behalf of 80 Sarkar.
On request made on behalf of AD Circle and the council for the petitioner. When do you want? 3 weeks?
6.
Up to 3 weeks. And item 15,
15, lordship.
same
Same.
order.
Oblige.
May I please, your lordship, I beg to mention for listing lordship. Matter is contempt matter, lordship.
Okay.
Any date, lordship.
14th.
Applies.
Item 66 of supplementary list withdrawal.
May it please your lordships. Lordships, I have been instructed to withdraw this case with liberty to file a fresh lordships.
Mr. R. Shamal and the council for petitioner press for withdrawal of the suit petition with liberty to file afresh. Mr. SMD Chishti, Learner Standing Council, appears for the secondary education department. Stop. Writ petition is dismissed on withdrawal with liberty as well.
69 of supplementary list. Motion, personal opinion.
Wait, please, Lord. Well, pursuant to your lordship's direction, my lord, the DEO, the inspector of school, Dibrugarh, my lord, he is here, my lord. My lord, we have received the original record.
Why could you not submit the records on the first day?
My lord, I tender my apology for misunderstanding.
I can't hear you. Yeah.
My lord, I tender my sincere apology for my mistake, and I assure that it will never happen again.
No, why could you not produce it? For what reason?
I've been
You
told,
didn't understand the court's language?
I know, my lord. I'm,
may I, I've been told, my lord, inadvertently, my lord, the original suspension order that was communicated to the.
That is correct. That is what I've already
Yes,
recorded.
yes, ma'am. That is done, my lord. Inadvertently, he thought, my lord, the suspension order in original, my lord, instead of the record, the entire record.
Okay.
But anyways, my lord, the petitioner, my lord, now has been reinstated, my lord, by 25th of October 2024 order from this. My lord, may I just place this one?
You've got it?
No, lordship. I have not been served, lordship. The petition.
It's a recent order, 25th of October. The director has reinstated the petitioner. Okay, then. May I apprise one thing, my lord?
One way. Have you got a copy?
Lordship, not yet, lordship.
I'll give him.
We can, you wanted the reinstatement of the order,
Yes, yes.
then we can close the writ petition.
Yes, lordship. Yes, lordship.
My lord, may I just apprise one thing, my lord? Here, the petitioner, my lord, pursuant to his provincialization, my lord, he never reported duty. However, my lord, in connection to arrest of in some criminal case, my lord, he was suspended. The lordship will also make an observation that the petitioner will report his duty, my lord, forthwith, my lord, upon serving this order of reinstatement, my lord, as per his provincialization order.
Okay, Ms. M. Nirola, learned counsel for the petition. Para, the district elementary education officer of which district?
My lord,
Dibrugarh. Is present in court today and submits that inadvertently he has furnished only the original suspension order and not the reports. Stop. He therefore tenders his unconditional apology before this court. Stop. Follow. Mr. B. Kaushik, learned standing counsel, Elementary Education Department, has furnished an order dated 25th October 2024, by which the petitioner has been placed under, has been reinstated back to service in his original place of posting with immediate effect. Stop. Para. The petitioner, while serving as a tutor in Somarpit ME School, was placed under suspension by an order dated
Wait.
21/3/2022.
May I clarify one thing? The Lordship will kindly see page 17, my lord, the provincialization order. He was provincialized in the school Sasasdi High Secondary School, my lord. As a tutor, my lord. And pursuant to this order, he never reported duty. He never joined.
Lordship, that the school has not been amalgamated. It is reflected in the suspension order, Lordship itself. Five, copy forwarded to 5 Sri Gopal Prasad Shah, tutor, Samarpit ME School, Lordship.
While serving as
That is what the mistake has happened, my lord. That
Somarpit ME School was placed under suspension by an order dated 21/3/2022, issued by the District Elementary Education, Dibrugarh. Stop. By way of the present petition, the petitioner is challenging the suspension order dated 21/3/2022. No, that's all like this. Cancel the whole matter. While the petitioner was serving as tutor within bracket H, head of Sumarpit ME School under the Block Elementary Education Officer, Lahore. He was suspended he was placed under suspension by an order dated 21/3/2022 in connection with Lahore Police Station case number 43 of the 2022 under section 448 of the 333 of the 353 of the 506 IPC. Stop. By way of the present petition, the petitioner is challenging the suspension order dated 21/3/2022 on the ground that the petitioner has been discharged from the said case and therefore the suspension order should be revoked and the petitioner should be reinstated back to the service. Stop. Para. However, during the pendency of the writ petition, as the petitioner has already been suspended, learned counsel for the petitioner submits that the writ petition may be closed. Stop. Accordingly, the writ petition is closed. However, with the direction to the petitioner to report back to his original place of posting as directed in the reinstatement order dated 25th October 2024.
And the provincialization order dated 5/2/2021.
That I'm not saying much.
Well, because that's the crux of the matter.
Here, what is heavily in the original place of posting?
Because he will get the benefit of that period, well, because he has never reported duty. And that was, and immediately after the provincialization order,
Then how about the suspension order?
suspension was a deemed suspension, well, in connection to the arrest.
And how about the reinstatement order?
That is in the,
With
because
the
of the,
reinstatement order,
yes.
says so and so tutor Somarpit ME school.
Yes.
That Somarpit ME school, well, he has been provincialized, and the base school is Sasaji Higher Secondary School, well. The Lordship will kindly see page 17 of the writ petition only. That's the provincialization order. And my lord will find the name of the recognized upper primary school, Somarpit ME school. Name of the appointee Gopal Prasad Sir, tutor.
Where I said, while the petitioner was, huh? You said, just before that, you said, the petitioner was provincialized by an order dated 5th February 2021. Issued by the Director Elementary Education Officer as tutor.
And terms and condition number 1, man.
Where the best school is shown as Chachachi Higher Secondary School. And the close one of the terms and conditions provides that the petitioner will join in the best school. Stop. Huh? Then after that.
Personal opinion.
The order dated 25th October 2024 is placed on record. And the personal appearance of the District Elementary Education Officer, Dibrugarh, is dispensed with.
Grateful.
67 of supplementary list, motion. Well, I received the instruction, my lord. As per the advertisement and as per the rule, my lord, he has no qualification on that. He has not submitted anything on that particular clause, my lord. And government also been clarified that without that, you cannot accept it. We got, and already, my lord, several my lord, candidate has been rejected on that ground. He has no requisite qualification, my lord, on that issue, my lord. Degree and diploma in adult education, that is his lack, my. No. All. Para 3, it is clear now. Something.
Yes. Yes. May preserve. Let me come to page 27. I'll just try to impress on.
When is the interview?
Sorry,
When is the interview?
today it is going on.
Today.
Today it is going.
Page
Page 27
Oh,
of the writ petition.
yes.
The essential qualifications, Lordship. Firstly, the master degrees in any discipline, humanities, social. Secondly, degree, diploma in adult education or social work. I am not claiming adult education, but I am claiming that I have a degree in social work. I have a degree in master degree in social work. Well, on last
You have a master degree in social work, that one qualification you have. satisfied. All right, but the number two's qualification, that is a degree in AE or social work. Do you have it?
Yes, Lordship, the definition of degree. Lordship, I'll make 2, 3 alternative arguments. The definition of degree, the state cannot decide what is a degree. The qualification is degree. Degree is conferred by the UGC. Now, degree, the definition of degree is in section 22 of the UGC Act. UGC being a institution, an act made under entry 66, these acts are made under entry 25 of the Constitution of India, concurrent list. Now, entry 25 is subject to entry 66 as per the entry itself. Therefore, if there is a difference of opinion between the center and the state, the center will prevail, firstly. Secondly, section 22 defines a degree. The UGC gives a list of degrees. In the list of degrees, master of social work is a degree. Therefore, my argument is that somebody who is master in social work qualifies both the thing. Lordship, I'll just show the definition first.
Mr. Bora, don't make absurd
My lord.
submissions.
It is as per the act.
Don't
very
make
clear.
absurd submissions.
And secondly, Lordship, if Lordship takes these qualifications as a continuous qualifications, master degree and diploma, but this is a specialized qualification.
Okay, do you have a degree?
I have a degree in computer application.
He don't have any degree in
Now,
this requirement.
suppose my alternative argument would be, if suppose the advertisement requires a bachelor degree in social work, what they are saying. Suppose it requires a bachelor degree. For a moment, let us presume. Then also, I have a higher qualification, that is a master degree. There are several judgments of this High Court also, Supreme Court also, that if I have a degree in a same channel, higher degree in the same channel, then I have to it has been taken to have a presupposedly the bachelor degree, Lordship. That is our judgment is also there from this High Court. From what I am trying to do, Lordship would ultimately decide whether the definition of degree in the Central Act or the State Act will prevail. Lordship would decide that if I have a master degree, but I don't have a bachelor degree in social work, whether that will satisfy the requirement or not. I possess a higher qualification.
I got your point. Since you have a degree, master degree in social science.
Yes, my one certificate, one satisfied both the qualification.
That would automatically imply that you have a higher degree.
Yes.
In social science.
Social work.
Social work. And therefore, the degree, it would be implied that you have a degree in the social work, isn't that?
Yes.
It can be implied.
Yes.
That's what you're trying to say.
No, Lordship, I have a higher degree in the same channel.
Same channel.
Whether that is acceptable or not, there are some judgment of this High Court, Supreme Court also that I have brought, where it says that if I am possessor of a higher degree, that will satisfy the requirement of the advertisement. Lordship will kindly have a look at the definition of degree.
Where is that?
UGC. The right of conferring section 22(1). The right of conferring of grant of degrees shall be exercised only by university established, incorporated by under a central act, a provincial act or state act, or any institution deemed to be a university under section 3 of an institution specifically empowered by an act of parliament to confer or grant degrees, save as otherwise provided, no person or authority shall confer or grant or hold himself or itself out of entitled to confer or grant any degrees. For the purpose of this section, degree means any such degree as may with the previous approval of the central government be specified in this behalf by the commission by notification in the official gazette. Now at page 55, I have annexed also a notification in the official gazette where and there is on notification of 1998 also.
It's 55.
55. Lordship, in exercise of the power conferred under subsection 3 of section 22 of the University Grants Commission 1956, University Grants with previous approval of the central government hereby specifies the following degrees for the purpose of this section. Now, bachelor degree, master degree at 10, there are 3 types of degrees: bachelor degree, master degree, and doctorate degree. Now at 10 is the Master of Social Work. Now nor the advertisement nor the state rules in the advertisement itself clarifies.
10? What 10?
10 serial number 10 in the column of master degree, Lordship would see Master of Social Work. So as per UGC, which is the central authority, it's a degree. Now in the rules or the advertisement.
There's no dispute that you have a master in social work.
Advertisement as per the act, my lord.
But the advertisement does not clarify. Does
Then
not.
he has to challenge it, my
No,
lord.
no,
That has got
no,
clarified already.
No, does not clarify. Lordship, does not clarify whether what degree is required. It just mentions a degree. Now, when there is ambiguity in the rules, so then what happens, Lordship? In that line also there is a judgment. Suppose the rules does not specify, there is an ambiguity in the prescription in the advertisement. Then the benefit would go to the candidate, Lordship. That is what I am submitting, Lordship. Lordship,
Okay.
the Lordship, 2015, there is a 2015 judge. Into DD. Dada karne ase niki eta? Here, in this case, what had happened, he had a BSc degree with forestry as major, but the advertisement required with a specialization in forestry. Now, Lordship, at para 15, in our considered view, firstly, that if there was any ambiguity or vagueness noticed in prescription of qualification in the advertisement, then it should have been clarified by the authority concerned in the advertisement itself. Secondly, if it is not clarified, then the benefit should be given to the candidate, then to the respondents. Thirdly, even assuming that there was no ambiguity or vagueness, yet we find that applicant was admittedly having BSc degree with forestry as one of the major subjects in graduation. And further, he has also having master degree forestry, MSc forestry. In the light of those works, we are of the view that the applicant was possessed of the prescribed qualification to apply for the post in question. And his application could not have been rejected, treating him ineligible candidate for not possessing the prescribed qualification. In our view, if a candidate has done BSc in forestry as one of the major subject and has done MSc, then in absence of any clarification on the issue, the candidate possessing such higher qualification has to be held to possess the required qualification to apply for the post. In fact, acquiring a higher qualification in the prescribed subject was sufficient to hold the applicant had possessed the prescribed qualification. It was coupled with the fact that forestry was one of the major subject in graduation due to he was able to do the master in forestry.
Para 5.
Lordship, of this. By notification dated 27, JKPSC advertised 23 posts of Jammu and Kashmir Forest Service Range Officer Grade 1 and invited application for eligible candidate. The eligibility qualification mentioned in the notification was BSc Forestry or equivalent from any university recognized by ICAR. The appointment to the post was the appointment to the post was to be made on the basis of written test, viva voice, working test, and medical test. The applicant applied for the said post. May I read para 6 also?
Yes.
By notification dated 8/9/2010, JKPSC declared the applicant as an ineligible candidate for appointment to the post of range officer. On 7/10/2010, the applicant sent a representation to JKPSC to reconsider his case, as according to him, he possessed a qualification prescribed for the post. On 11/10/2010, the applicant sent another representation to the JKPSC requesting it to allow him to participate in the selection. Since no action was taken on the representation and the appellant filed a petition being SWP number 2699 of 2010 before the High Court for issuance of writ of certiorari for quashing the said notification 8/9 and further direction to the JKPSC to allow him to participate in the selection process. The learned single judge by interim order dated 24/11/2010 allowed the applicant to appear in the written test examination subject to the outcome of the writ petition. Accordingly, the appellant appeared in the examination on 22/2/2011. The results of the written test were produced in the court. By JK was declared the appellant to be successful. The learned single judge permitted the applicant to appear in the interview. On 22/7/2011, JKPSC published a list of selected candidates who were recommended for appointment on the basis of merit, but the list did not reflect the name of the applicant. By order dated 12/11/2012, the learned single judge dismissed the writ petition. Against the said order, the appellant preferred the appeal being LPA number so and so before the High Court pending disposal of the appeal. The division bench by interim order directed one post of the range officer be reserved for the applicant. However, by order dated so and so, the division bench dismissed the appeal. Aggrieved by the said judgment, the
Bora, in this case, the advertisement was that the required qualification is BSc in forestry. Okay.
BSc in forestry, yes.
He was found disqualified.
Yes.
They found him disqualified because on the ground that he has done BSc as forestry as a major subject. That is the different. That
is different. Lordship.
Then after he completed his MSc in forestry. This is a totally different issue. This has got no connection with this.
Lordship, what I was from the judgment, I was trying to point out.
What the judgment said was that as the petitioner, as the appellant in the was having a BSc with forestry as a major subject.
Yes.
And he completed MSc with forestry.
Yes.
He is eligible.
Yes.
This is what the Supreme Court said.
Yes.
Here in this case, this is totally different. You have an MSc in social work.
Yes.
But a degree in computer application.
Computer application.
You do not fulfill the criteria laid down in the eligibility column number 2.
Lordship, what from
And
the
therefore, they had rightly rejected your case.
From the judgment, what I wanted to point out that the rules does not say specific. Lordship, if the qualification is read as a continuity of the 2 is read as a continuity of 1, then yes, Lordship, I do not have a graduation degree. But if it is taken as a specified qualification, the rules also does not specify whether it should be a postgraduate degree or whether it should be a graduate degree.
Show me if there's any ambiguity in this advertisement.
Advertisement.
What I wanted to point out from this judgment is because the rules, Lordship would see the advertisement and the rules also. In the advertisement, degree/diploma in AE or social work or community development or rural development. Now, it merely says a degree. It does not clarify. In fact, the state has no authority to clarify.
It says degree diploma
Adult education.
in
In social work
adult education or social work.
or social work. I am claiming social work. Now,
You are claiming social work as a master's degree. But as a degree, you have only computer application.
but Lordship, what I
Requirement, let us be very clear.
yeah.
Let us not argue for the sake of argument. Let us be very clear. First essential qualification, master degree.
Yeah.
That there's no issue on that. You have it.
Yeah.
The issue is the second degree, second qualification. Second essential qualification.
Yes, Lordship.
Here it says degree diploma in AE, social work, or community development, or rural development, or women study, or communication, journalism,
That is-
degree in teacher education.
Admittedly, there is-
If you have at least one of these degree, this court could have said, yes, he has it, allow him to sit. But from your own mouth,
we have no-
you have said that you have a degree in computer application.
Bachelor degree in computer application.
After that, we don't have, there's nothing more to argue.
Lordship, what I wanted to show that they do not specify whether a graduate degree or postgraduate degree, because this is specific. So if suppose Lordship takes it as graduate degree, then Lordship, there is the rules also. Then they could have, as per the judgment, they could have cleared it in the advertisement. That is one option they have. If they are now
Where are the rules?
yes, Lordship, I have annexed it.
Yes, rule annex. It will also say.
Annex page 26. Page 26 is the operative part. Then it would be an adding some words to the statute, Lordship.
Page 26?
Page 26 is the schedule of the rules. Entire rules I have from page 49. Sorry, Lordship, page 52. I'm sorry.
Page 52.
From 49 it starts. Only the operative part. Lordship. Now the schedule, Lordship, qualification. Lecturer in district resource unit, masters in humanities, social science or science, that is a general qualification. Now secondly, this is the specialized qualification is required, degree/diploma in adult education, non-formal education, or social work, or social worker it is given, but it has to be work. Now, Lordship, if suppose we add graduate degree, suppose we take it as graduate degree, then it will amount to adding some words that maybe the legislative intent posted like this, that degree. Now, what is a degree has to be seen from the UGC Act.
Are we going to go into all this? If then we have to file your affidavit.
No, that rules is very clear. Rules is not.
Lordship,
We saw I see no ambiguity in the rules. I saw no ambiguity in the advertisement.
And also government instruct us to not to take any who has no qualification, my lord. The candidate having conformity with the advertisement should not be considered. That is the instruction by the government also, my lord.
Lord.
And very clarify, my lord, government clarify us, my lord. Essential qualification is required, is implied at bachelor degree.
Interpretation of 72 judgment.
My lord,
72
your
judgment.
lordship kindly see, my lord, in 5th of October, he was rejected, my lord. After 24 days, my lord, he has been, my lord, filed this petition, my lord.
Lordship, if we go by the literal interpretation, then postgraduate degree also comes in, because it is different from one. Lordship, if we add the word graduate degree or bachelor degree, that would be adding something to the statute, Lordship.
Yes.
Para 18, Lordship, just to show that how far the respondents can Mainly is para 20. Para 16, Lordship would see first. A test laid down by Blackburn J in R versus Claiborne to determine what is the correct presumption arising out from an omission in a statute should be was whether what was omitted but sought to be brought within the legislative intention was known to the lawmakers. Would there be supposed to have omitted intentionally? It makes no difference, says Clark, in a statutory law that the omission on the part of the legislature was mere oversight, and that without doubt the act would been drawn otherwise had the intention of the legislature been directed to oversight at the time of the act was under discussion. In the case before us, it could not possibly be that the question to be dealt was not known to the legislature. It could not even be said that the qualification of the electorate as well as those elected was not were not matters to which the attention of the lawmakers, both the Constituent Assembly and the Parliament, was not specifically direct at all, or that the omission must be by mere oversight. The provision discussed may demonstrate amply how legislative attention was paid to the qualification of the electorate, as well as of the elected in every case. Hence, the correct presumption in such a case would be that the omission is deliberate. Therefore, the legislature, what I submit, Lordship, later in the judgment says that adding some words, Lordship, so the omission to add the bachelor word or the omission to add something was deliberately done to allow master degree holders also. That is my submission. But therefore, Lordship, I can argue out, Lordship, today if Lordship allows me to sit in the interview.
I can't. Knowing very well that you don't qualify, this court cannot permit you to sit for that. If you want to argue by way of an academic interest, that we can permit.
Lordship, no, Lordship, I'll bow down to your Lordship. Lordship, what Lordship will decide, my aim was to argue the matter. I have argued it. Lordship will decide.
Okay. Yes, Mahando?
My lord, it is already, my lord, there is a rules, my lord, as per the rule, my lord, that advertisement essential qualifications are, my lord, that is formulated, and government give the advertisement, we have advertised, my lord, and we sought for clarification also, that I have already instruction in place, my lord. That these are the all, my lord, your lordship kindly so far serial number master degree is concerned, he has. So for serial number 2, this is also not, he has not, admittedly, he has not any degree certificate on that essential qualification. So that's why, my lord, not only him, my lord, your lordship kindly see, so many candidates, near about 79 candidates in similar situation and rejected. And that rejection order was published in, my lord, October 5th. 5th of October, my lord. Your lordship kindly see page 44, my lord. These all 3 qualifications are essential, my lord.
When is the date of this?
My lord.
Diploma.
Where's the date? Page 34.
Page,
Rejection?
a rejection order at page, my lord, your lordship will find it is really started from, my lord, page 34, my lord.
No, that's fine.
That is,
But
my lord,
on
on
the
the website, it was published on 5th of October. That is not reflected because he downloaded from the internet, my lord. That's why that is not there, my lord. It is 5th of October, it was published, my lord. And your lordship kindly see that how many candidates were rejected on that issue, my lord. No essential qualification. And very clearly that was pointed out in his application, my lord. And he is not certain to advertise. So if he has any, my lord, order, he can, my lord, challenge the rule, my lord. Because advertisement with a conformity.
Your serial number is 186.
Yes.
186, my lord.
Yes.
No degree and diploma. So that's my submission, my lord. And this stage, my lord, If he, my lord, allow him, then it will be a floodgate, my lord. Tomorrow, all these 69 will come, my lord.
Tomorrow, today is the last day of
But whatever
interview.
it may be, my lord, but.
Tomorrow, everyone
But then,
will
my
miss
lord,
the
those
bus.
who have a possession or a requisite qualification, they will say, my lord, why you allowed the person who is not, not by advertisement, not eligible?
Lordship, in one of the judgment, that argument was made by the respondent that many other would come. The court said that nobody is before the court, and so if somebody is before the court, we have decided it. That is one thing, Lordship, and moreover, whatever Lordship decides, but from a bare reading of the, suppose, master degree and degree, now some word is missing, Lordship. They have to clarify that in the advertisement itself, with that graduate degree. In the advertisement itself, it stands clear, the graduate degree. Because ultimately, these are specialized qualification. Somebody, I am postgraduate, in fact, Lordship, I am postgraduate in social work. I am not saying right now because I have obtained it after the advertisement, last date of advertisement. Otherwise, I am postgraduate in social work, Lordship.
That is fine.
No. So, whether I am suitable for this post or not, that is one thing, Lordship. And there is some, because some word is missing, Lordship. So, if some word is missing, the benefit, Lordship, and I have already shown the definition of degree. Degree can only be defined by the central authority.
You have a master degree in?
Master in social work, page 12. Master, page 13, Lordship, master degree in social work. And I have a net also, page 14. I am net qualified in social work. Page 14. Lordship, page 14, Lordship, have a look.
Yes.
UGC net for eligibility of assistant professor held on 28/12/2014 in the subject of social work. My national eligibility test I have cleared in social work. Lordship, page 15 is my PhD certificate.
Social work?
In social work, Lordship.
But the qualification for master degree is also humanities. Humanities, social science, and science.
Yes, Lordship, for that.
That's why, my lord, it's very intention is very clear. Your lordship kindly see, you have a master degree in, my lord, any subject, but you have to possess degree in that particular subject, either diploma or degree.
Social work is a part of social science, Lordship.
Oh, that's fine.
I have also annexed the Nehu and Tezpur University. That is a part of social work. Suppose Lordship, would see somebody is master degree in economics, suppose. Humanities, somebody is master in economics. If that person wants to contest this post, he has to come back to the pre-university level, do the bachelor degree in social work. Then somebody who is master in something would come back to do bachelor. That's why a provision has been made only in social work that you can directly go to the master level. Therefore, my submission is that the intention is not that degree is only bachelor degree. And suppose if we take also what the contention of the respondent, suppose it is a bachelor degree, then also the word bachelor is missing. Lordship, the respondent will not add some word to the statute, Lordship. It has to be given the literal interpretation. What is degree is given in the UGC Act. Whatever it is notified, it is a degree. Now, Master of Social Work is a degree as per UGC. Lordship, one large judgment, Lordship, I wanted to show 95 order. 95 নতুন কেন তো মোটো মোৰ কপি এটা দিম 95 one last attempt. Para 41, it discusses what happens if there is a inconformity with the central law. para 41, Lordship, what I wanted to show, I wanted to cut it short at Roman 6. Roman 6, Lordship. Roman 2, firstly, Roman 2 for once, to the extent that the state legislation is in conflict with the central legislation, though the former is purported to have been made under NT 25 of the concurrent list, but in effect it encroaches upon legislation, including subordinate legislation made by the center under NT 25 of the concurrent list, or give effect to NT 66 of the union. It is void and inoperative. 6, Lordship. However, when the situation seats are available and the state authorities deny an applicant the same on the ground that the applicant is not qualified according to its standards or qualification as the case may be, although the applicant satisfied the standards and qualification laid down by the central law, they act unconstitutionally. So also when the state authorities derecognize or de-affiliate an institution for not satisfying the standards or requirements laid down by them, although it satisfied the norms and requirement laid down by the central authority, the state acts illegally. Therefore, Lordship, if I satisfy the definition of degree as per the UGC Act, now as per the State Act and the advertisement, supposedly I don't satisfy. Then, Lordship, the degree definition of degree in the Central Act will prevail, Lordship. That is my
conflict. There is no question of conflict. It is 309 rule, my lord. The state shall take my.
But 309 rule, if there is an act already occupying the field, Lordship, 309 would not come. 309 would come only when there is no act of parliament. This is an act of parliament.
I'll dictate it too. Now there's already one open.
Deeply.
After this, that medical matters will come. No?
And the course curriculum of the bachelor and master is the same.
After this case, that medical college, medical admission, those cases will be taken up. So,
Deeply.
My lord. And he got serious injuries.
okay,
Yes, my lord. Therefore, maybe fixed after 2 weeks.
okay, I'll request. Met on behalf of Mrs. Badia, legal counsel to the decision. Please, doctor, 2 weeks.
Yes, my lord.
Okay.
I mean,
That's fine. Heard Mr. B.V. Boral and it's counsel for the petition. Also heard Education Department, who appears? B.K. Boral and it's standing counsel?
My lord.
Secretary,
Elementary.
elementary education. For the respond number 1. Mr. T.J. Mandal and it's senior counsel assisted by Mr.
Ms. P. Sharma Lord. P. Sharma Lord.
P. Sharma, Leonard Council. No, Mr. T.J. Mandal, Leonard Senior Counsel, and as well as standing, just T.J. Mandal, Leonard Standing Counsel, huh? Assisted by Ms. So and so. Appears for respondents 2, 3, 4.
2, 3, and 4.
2, 3, and 4.
2, 3, and 4. SCRT, anybody? B. Gogoi, Leonard Standing Counsel, SCRT for the respond number 5 and 6. UGC?
A Samuel, Lordship.
Yes, A. Chamal and Standing Council UGC for the respond number 7. Para. The petitioner is having a master's degree in social work as well as You're having
Anything, national eligibility test in social work and PhD.
PhD in what?
In social work,
As well as national
in social work,
eligibility test.
PhD. PhD in social work.
No, no, and he's also qualified
Hmm.
under the national eligibility test, as well as has a degree, as well as has a PhD. Stop. Pursuant to a advertisement.
To 23, 2 is starts, 27 is the relevant. 27. It starts-
Number 20 of like 2022. Issued by the Deputy Secretary, Assam Public Service Commission. On 13 September 2022. The petitioner applied for the post of lecturer, district resource unit within the bracket DRU. Stop. Draft. Is this a notification or this? Page 36.
Page 30 is, there is a reject list uploaded in the website of the APSC. my lord.
After the APSC uploaded the list of candidates whose applications have been rejected
On 5th of October, my lord.
on 5th of October 2024. Stop. The rate, comma. The name of the petitioner appears at serial number 186.
Page 44.
And his ground of rejection is that he has no requisite qualification. Stop. Para. The eligibility condition, the essential qualification, not eligibility, for the post of lecturer, district resource units within bracket DRU, as notified in the advertisement dated 13th September 2022. Reads as under page 27, A to A. Stop. Para. Mr. D.B. Boral and the counsel for the petition submits that the petitioner has a master's degree in social work, as well as qualified net, and also has a PhD degree in social work. Stop. He therefore submits that the petitioner, having all the requisite qualification prescribed for the post of lecturer, DRU, his case could not have been rejected. Stop. He further submits that as regards the essential qualification within bracket Roman 2, it is prescribed only as degree oblique diploma in AE or social work or community development or rural development or women's studies or communication or journalism or degree in teacher education with specialization in adult education with 55% marks. Stop. Therefore, comma, the therefore clause 2 of the essential qualification does not prescribe that the candidate should have a graduate degree in the said subjects. And as the petitioner already has a master's degree in social work, comma, the petitioner should have been permitted to appear in the interview, which is to be held today, 28 October 2024. Stop. He, however, submits that insofar as the graduate degree of the petition is concerned, comma, he is having a degree in computer application. Stop. However, comma, as in the advertisement dated 13 September 2022, there is no mention of graduate degree in the required essential qualification with regard to the post of lecturer, comma, district resource unit. The master's degree held by the petitioner in social work would indicate that the what we were saying would indicate that
The essential qualification as per advertisement is met.
that the essential qualification as per the advertisement is met. Stop. Para. Learned counsel for the petition has also drawn the attention of this court to the Assam District Institute of Education and Training within bracket diet service rules of 2010, particularly with regard to Schedule 2, wherein it also prescribe wherein the qualification prescribed for lecture in district resource unit within bracket DRE is prescribed. Stop. He submits that in the said schedule, there's no mention of graduate degree, and therefore, comma, in the therefore, the master's degree held by the petitioner in social work cannot be said that the and therefore the master's degree held by the petitioner in social work would qualify him for being called for interview for the said post of lecturer in DRU. Stop. You want to go into all this?
No, as Lordship pleases, no.
Okay.
Only Lordship, the UGC definition of degree I have mentioned.
But stop. Learned counsel for the petition also has drawn the attention. Where is that UGC
UGC section 22.
page?
Lordship, page 55. Page 55, Lordship.
Has drawn the this learned counsel for the petitioner has also drawn the attention of this court to the list of degrees specified for the purpose of section 22 of the University Grants Commission Act 1956, where
Serial number 10.
at serial number 10
Master degree.
under the master's degree column, it is shown as Master of Social Work within bracket MSW. Stop. Therefore, comma, the rejection of the petitioner for on the ground of not having the requisite qualification does not arise, and the petitioner should be directed and the respondents, particularly the APSC, should be directed to permit the petitioner to sit in the interview that is being held today, 28 2010-2024. Para Mr. T.J. Manda, Leonard, Standing Council APSC. On the other hand, submits that in pursuance of the draft advertisement received by the commission, the advertisement number 20/2022 was issued inviting applications for intending candidates for 65 numbers of posts of lecture in diet under the Directorate of SCRT, Elementary Education Department, including 8 numbers of lecturers, District Resource Unit within bracket DR. Stop. He submits that the required essential qualification for the post of lecturer within DRU is in consonance with Schedule 2 of the of the on top where I said Assam so and so rules. No? On top where I said Assam district studio so and so rules 2010. You within bracket you say rules of 2010 in short. Huh? It's in continue. It's in consonant with Schedule 2 of the rules of 2010. Stop. Drafted, drafted, comma. The commission, after receiving the applications, scrutinized the same and found that some candidates did not fulfill the criteria as laid down in the advertisement. Accordingly, their candidatures were rejected on the ground of not having requisite qualification and qualification, overage, improper treasury challenge, etc. Stop. He submits that the petitioner was rejected on the ground of not having the requisite qualification, inasmuch as the petitioner did not fulfill the minimum essential qualification under clause under column 3 within bracket Roman 2. Stop. For Learned Standing Council for the Commission also submits that the petitioner is a master's degree holder in social work and he has qualified net in social work but does not possess a degree or diploma in terms of clause 3 column 3 within bracket Roman 2. Stop. Further submission is made that there's no mention in the advertisement dated 13 September 2022 that a master's degree in social work would exempt a candidate from the second criteria of having a degree or diploma in the mentioned subjects. Stop. under the circumstances, comma, the commission, after scrutinizing the application made by the petitioner, rejected his case in as much as he does not have the requisite qualification as prescribed under column 3 within bracket Roman. Stop. Para. This court have considered the submissions forwarded by the learned counsel for the parties. Stop. Para. There's no doubt that the petitioner is having a master's degree in social work and he is a qualified net in social work and also possesses a PhD degree. Stop. However, comma, on the perusal of the essential qualifications for the post of lecturer, comma, district resource unit, comma, which is already been quoted here and above, comma, it is seen that the required essential qualification under 3 within bracket Roman 2 is a degree oblique diploma in AE or social work or community development or rural development or women's studies or communication or journalism or degree in teacher education with specialization in adult education with 55% marks. Stop. Para. To a pointed question made by this court to the learned counsel for the petition as to whether the petitioner is having a degree in any of the required subjects as specified in 3 within bracket 2, comma, learned counsel for the petitioner submits that the petitioner has only a graduate degree in computer application. Stop. Para. This court has also perused the rules of 2010, particularly Schedule 2, appended to the said rules. Stop. The qualification required for the lecturer in district resource unit, as per the advertisement dated 13/9/2022, is in consonance with Schedule 2 to the rules of 2010. Stop. However, comma, when the petitioner does not have the required qualification as required by 3 within bracket 2 for the post of lecturer, comma, district resource unit, comma, this court has no hesitation to come to the conclusion that the petitioner does not fulfill the requirements under 3 within bracket 2 of the advertisement dated 13 September 2022. In as much as he has only a graduate degree in computer application. Stop. Therefore, comma, this court does not see any infirmity in the action of the commission rejecting the case of the petitioner on the ground of not having requisite qualification. Stop. Accordingly, comma, para, there being no merit in the present petition, the same is equatory dismiss. Anyway, you have tried very hard. That much we can. Oh, what, I reported B Gogo, S Bora. No, there's not. Which one? B Gogo or you? S Bora. Then instead of B Gogo, it's S.
Lordship, sometimes we have to do this type of case
I know.
also.
That's why I'm saying. This court appreciates you've done a good job.
Deeply obliged.
70 to 78 and production list 1.
Production speed. Series. One production list 5564. Today that I have brought it. My lord, if your lordship turns to page 29. Page 29, the horizontal page, man.
Page?
29, annexure 2.
Ah.
Your lordship will find from bottom 1, 2, 3, 4, 5, 6, 7, 8, 9. Asif Iqbal Islam. This is a list, provisional select list for candidate round 3 of Assam State Quota, whose name appeared in Assam NET UGC 24 merit list of admission into first year MBBS BDS course session such and such Government Medical College and Dental Colleges of Assam. My name appears in that serial number 1228. But here in my case, my lord, college names are not shown. In which college I will go for counseling, I do not know. Well, that is why I am before your lordship. My name is there in the third round, but college has not been provided.
Yes, go ahead.
My lord, to my information, in item number.
No, on the
78, no.
production is here.
78, my lord, similar issue. I have got the instruction there that the last candidate under the unreserved category in this particular quota of 5%, his mark score is, my lord, 564. Petitioner is 553. Probably for that reason. he was not selected.
He is under the general.
Jail. And
Yes, unreserved. Unreserved cutoff is, my lord, 564.
564.
I am 563. But above me, my lord, there are candidates of 563 also there.
My lord, even under unreserved category, there's an open category, 5% reservation is there. So in that category, my lord, it is 564. The last candidate who has been selected.
1221.
No, I can't say, my lord, the name of the particular party who has been, my lord, or the candidate who has been selected. But the mark score that I've got the chart, my lord. In item 78, I've got the respective. They are also same candidate, my lord. In the initial stage, his name was there.
No, but that is the EWS. No, general.
EWS, my lord, is 557 under the unreserved category.
General is?
General is, my lord, 564. EWS is 557. In MBBS. In dental, it is below.
Okay.
So I
can have a written instruction tomorrow also in this case. Why it is not there? But this is a fact. Last candidate, my lord, that I
let them brought an instruction day after tomorrow on the Wednesday.
I can have a written instruction.
Wednesday, there will be some difficulty. We will have it tomorrow if you.
Yeah.
Well, I have some difficulty. If your lordship can witness the only single case, well, only the instruction.
Yes,
if they can give me in dental also, because if I have got a 64, because it confers both medical college and dental college. So if they can
my lord,
provide.
my information, my lord, instruction says it is also to be informed that all MBBS BDS seats under the government institution quota are filled up by suitable candidates through counseling. Third counseling is over, no seat is available at all. That's the position.
What I have understood, my lord, from instruction that up to 5th November time has been extended.
Oh, extended, but seat should be there, man. Already filled up with the persons with a higher merit position than the petitioner.
Because just now my friend has said that 564 was the last time. Last in dental, it is below. Dental, it is below. I got 563. If it is there, same thing. So, my lord, if it can be considered for dental, my lord, my case.
No, it's not a point of consideration, my lord. Whatever he has applied, accordingly it has been considered. Had he applied for dental, then he would have been selected, my lord. It's up to him, my lord, how he has applied. He has nowhere stated, my lord, in the petition. And that is not his case.
Just see how he has applied in the
Yes,
application.
Let it be on Wednesday, my lord. Let it come on.
Nothing, my lord, there in this case. Considering the infraction that.
Only thing, my lord, that there are similar orders are passed on 410 in other items, my lord. That order may be passed, my lord.
What similar?
What 410?
That order was there, my lord. Orderটা বাইর করে রাখিস নি।
But we are on 28 can today. Already the third round is over.
That this is the order, man.
What does it say?
My lord. Any admission made against 5% reservation for student of Assam State
That's
shall be
not
subject to
you-
outcome of this writ petition. In the meantime, petitioners are allowed to appear in the rescheduled second counseling without prejudice to
That
the.
one is over. It's all over.
My lord, that will be subject to outcome of the writ petition, my lord, that much.
Well, for that, my lord, now, my lord, since all the seats are filled up, let them first make them parties. I will give the list. Entire candidate, 74 or 75 candidates, let them make them party here. If they want that, it should be out. Subject to outcome.
So let it become on Wednesday, my lord, with
Well,
the.
heard Mr. P.K. Roy General and counsel for the petitioner on request made by B. Gogoi. Let us standing counsel health department. It's the matter on 30.
Well, one extra going to shop today.
Yeah, you're finishing next week. Just see what he has applied for.
Yes,
So,
yeah,
but
That one.
Advocate General is appearing or not? He's not.
Yeah, my lord, some difficulty on his part.
May it please, your lord.
Hmm.
My lord, this is a case of not 40% eyesight, visual impairment, low vision. In this case, my lord, the respondent number 4 has filed affidavit in objections. The other respondents have not filed any objection, my lord. But that is one aspect, my lord. Otherwise,
Who is the respondent number 4?
4 is the, my lord, director of medical education. In this case, my lord, the cutoff percentile of a PWD category is 45%, and the petitioner has obtained 72.79 percentile. She has been, my lord, allotted a seat in Diffu Medical College and Hospital.
Where that?
Page number 44, my lord, of my writ petition. Page number 47, my lord, I'm sorry. Second, my lord, 2915 is the serial number. Nadia Tabassum, college name Diffu Medical College, Diffu.
This is the first round of counseling, isn't it?
First round of counseling. After that, my lord, I was allotted a seat in Diffu Medical College, my lord. I applied for NEET under PWD category on the strength of, my lord, a disability certificate issued to me by competent authority, my lord, that I have annexed, my lordship will find. Page 32, my lord. This GMCH hospital, they issued this certificate, page 32. %40 eyesight disability, my lord. And on the basis of this, my lord, page 29 is the disability certificate issued by Joint Director of Health Services, my lord, under Department of Empowerment of Person with Disabilities, Ministry of Social Justice and Empowerment, Government of India. Page 29, my lord.
Page
29.
yes.
Point C, my lord. 40% permanent disability in relation to both her eyes. Page 29. Page 29. Now, on the basis of this, the certificate issued by the GMCH conducting my physical verification and my lord, the disability certificate issued under the Ministry of Social Justice and Empowerment, Government of India, I applied under NEET UG 2024 examination for admission, my lord. Accordingly, a seat was allotted in my favor, my lord. These two certificates have not been put to challenge by the respondent number 4 in his affidavit in objection.
Yes.
Only, my lord, they have done medical examination again and found the physical impairment to be for 40% itself.
Page
Page 93, my lord. Point D, my lord.
page 93.
Page 93, my lord, of their affidavit in objection of the respondent number 4.
Para
D, my lord. It is 3D, my lord. 3 A, B, C, D, they have given, my lord. This is the D point, my lord. Page 93, my lordship has got it. Married, my lord. That an admission notice was issued by the Director of Medical Education, Assam, flight number so-and-so, dated so-and-so, directing all the candidates who have been provisionally selected under PWD category to report with all their relevant certificates in original to the Office of Principal cum Chief Superintendent, GMCH, Bhangagar, Guwahati Hospital for verification of their disability status by the medical board on 2/9/2024, failing which his or her allotment shall be cancelled. Pursuant to said notice, the petition appeared before the medical board on 2/9/2024, and the said board, after due examination of the disability status of the petitioner, came to the finding that the disability of the petitioner is 40%. So their medical board has also, my lord, identified my disability to be of 40%. But my lord, if my lordship may kindly come to para 5 at page 94, this is where the respondent instrumentalities have misconstrued. Because, my lord, if my lordship, before coming to para 5, if may I take your lordship at page 86.3, page 86.3, my lord.
of the same affidavit.
Same affidavit, my lord. The specific case of the respondent, my lord. 8th line, my lord. The candidature for admission to MBBS course program under PWD category under various colleges will be governed as per relevant NMC guidelines, which are given under Appendix H1 of the guidelines regarding admission of student with specified disabilities under the Right to Person with Disability Act 2016 with respect to the admission in MBBS course during post-examination and counseling process issued on 1/8/2023, Appendix H, my lord. My lordship will find at a notification, my lord. That is, their notification is at page 135. 135, my lord. Types of disability, appendix H1 that they were relying, my lord. Types of disability, visual impairment, low vision, equal to or more than 40% disability, no eligibility for medical course. But my lord, if less than 40% disability, then eligible for medical course, not eligible for PWD quota. And nothing has been provided under eligible for medical course as well as eligible for PWD quota. This is proviso has been given, my lord, at point B. That proviso is below in the chart, my lord. Star, person with visual impairment, oblique visual disability of more than 40% may be made eligible to pursue MBBS course and may be given reservation subject to the condition that the visual disability is brought to a level of less than benchmark of 40% with advanced low vision aids, such as telescope, magnifier, etc. So, my lord, my case, my lord, it is 40%. According to my disability certificate, according to finding of the medical board, it is 40%, my lord. Only they have misconstrued, my lord. I earlier submitted at para 5, my lord, page 94. According to the respondents,
Page 94.
94, para 5, my lord. Last para, my lord. May I read, my lord? Further, the deponent begs to submit that in pursuance of the notification issued by Medical Council of India, file dated 13/5/2019, visual impairment less than 40% disability shall be eligible for medical course if fulfill the other criteria, but shall not be eligible for PWD quota. This is where they have misconstrued, my lord. Because in my case, my lord, it is not less than 40%. It is exactly 40%. And my lord, if a proper medical examination would have had been done by, my lord, by the use of special aids, my lord, then her disability would definitely come below the 40% and she would get, my lord, we get eligible for PWD quota also, my lord. Not only admission in, my lord, MBBS course.
Let us see that notification H1.
H1 is page
135.
135, my lord. B, type of disability. B, visual impairment. Now there is a star, my lord.
Yes.
Low vision. Top, my lord, eligible for medical course, not eligible for PWD quota.
1 minute. Where is that? Where?
Up at top, my lord.
Uh-huh.
Serial number, disability type, types of disability. Then, my lord, eligible for medical course, not eligible for PWD quota. They have construed it, my lord. Less than 40% disability. Low vision, my lord. Then second, my lord, eligible for medical course, eligible for PWD quota. Nothing is mentioned because, my lord, the proviso that has been given is relied on the base, my lord. The last paragraph of the chart, my lord. Disability is brought to a level of less than benchmark of 40% with advanced low vision aids. If, my lord, disability is 40%, then the, as per this notification, my lord, 2019 notification and appendix H1, my lord, the criteria to conduct a medical examination is to see by using advanced low vision aids whether candidates benchmark disability can be brought to a lower benchmark, my lord, lower level below 40%, making her eligible for admitting in the PWD quota. But in this particular case, though the finding of the respondent instrumentalities that I am having 40% visual impairment, But my lord, they have misconstrued it, and that is why para 55, I already showed at page 95. Para 5, my lord. Page 94. Last para, my lord. Further, the deponent begs to submit that in pursuance of notification issued by Medical Council of India, number so and so dated 19, visual impairment less than 40% disability shall be eligible for medical course if fulfill the other criteria, but shall not be eligible for PWD quota. My benchmark disability is not below 40%, my lord. That they themselves has assessed it. Medical board itself has assessed my disability to be of 40%. And then that is to their own contrary, the respondent number 4 has submitted that less than 40%. And holding that I am not eligible for PWD category, my lord. Wherein, my lord, this particular observation is in clear contradiction with the notification dated 2019, my lord, which categorically specifies how to conduct a medical examination to identify whether a particular candidate is eligible for admission under PWD quota or not. Appendix H1, my lordship. Then how they have come to this conclusion, my lord, that also page 121, page 110, my lord. This is the board's comment, page 120. Is the board's comment, my lord, comment sheet. Page 121, serial number 63. Serial number 63. This is directly, my lord, 40% visual impairment, category 3A.
Category 3A.
3A, my lord. So that is low vision.
So what is
So-
this category 3A?
3A, yes, sir. 3A is the, my lord, there is one guideline that has been provided under, my lord, Rights of Person with Disability 2016, a guideline as to how to do, how to subject a particular candidate to medical examination to see whether he or she falls under the PWD category or not. At the very outset, my lord, my submission is that, my lord, firstly, this particular act is a beneficial legislation. The act says the criteria of how to identify the PWD status of a particular student or a individual. Here, my lord, a competent authority, after proper medical examination, grants a PWD certificate to a student. On the basis of that PWD certificate, the student applies under PWD category. Then, my lord, there is a notification which the state respondents instrumentalities follows to find out that whether a particular student falls under that category or does not fall under the category. The criteria has been given under H1. Now, my lord, in this particular case, my disability certificate has not put to challenge. That is, my lord, nothing is there in the affidavit which says that the disability certificate is incorrect or it has been fraudulently obtained, or, my lord, it is, my lord, not consistent with the percentage of disability under which I am claiming a seat in a medical institution which has been allotted to me. But, my lord, the notification 2019 provides, my lord, when a particular student applies under PWD category, then these are the basic criteria, these are the basic guidelines under which her disability has to be assessed. As per H1 note appendix, my lord, if a particular candidate submits a medical certificate saying that the candidate has 40% disability, then to ascertain that whether she would be eligible for the PWD category or she will not be eligible for the particular category is provided in that appendix H1, my lord, wherein by using special age, it has to be seen that whether her disability comes below 40% or doesn't come below 40%. If it doesn't come below 40%, even after applying the age, my lord, then she is not entitled. If her disability is more than, my lord, a particular percentage, not eligible. If her disability is 40%, but upon using those special aids, her disability can be brought below the percentage of 40, then that particular student is entitled for, my lord, PWD quota, wherein in this particular case has happened, my lord. But the respondent instrumentalities has wrongly construed the entire subject, my lord. What they have done, my lord, they have subjected the candidates to a new set of, without adhering to the earlier certificates which was allowed to a particular candidate after properly getting medically examined by medical institutions. They have been again medically examined, and, my lord, his or her disability status has been put to new ascertainment, my lord, by giving grades.
No, no, issue is this.
My lordship.
After your examination, the competent authority issued your disability
My lordship.
40%.
My lordship.
You applied under the disability
I applied.
certificate
I applied.
under the PWD category.
I applied, my.
You were selected in the provisional first round.
Selected, my.
Okay.
Selected.
After you called for a medical checkup.
I was called before that, my lord. Counseling was done.
No, no, counseling,
Allotment
no,
was given. Then, my lord, I was called for medical checkup. But as per their
for verification.
my lord, my lord,
For verification of that earlier certificate.
in terms of 2019 guideline that they need.
So
to
what
follow.
they did was
My lordship,
they found that you have 40% disability
found, my lord,
and then rejected your case.
rejected my case.
Your case is that
My lordship,
if I'm having 40%,
my lordship,
in terms of that appendix H1,
H1, my lord,
proviso should have been applied.
applied, which is not applied in this
That's
present
all.
case. That's all, my lord.
So what do you have to say for this?
Yeah.
Whether you have applied the proviso?
Yes, my lord. Here, my lord, first of all, my lord, as regards the contention of the petitioner, that, my lord, the disability certificate which the petitioner has prior to even, my lord, applying for the counseling or in the need examination issued by the concerned authority as per the statute, my lord, Disability Act, my lord, that is not required to be challenged, my lord. The fact that, my lord, every candidate who has applied under PWD category, persons with disability category, in, my lord, need, they have been informed, my lord, in the information bulletin itself that that particular certificate issued by the competent statutory authority, with that on, they can only apply in need, my lord, under that category. Moment they are selected, they will have to appear before a medical board duly constituted by the counseling authority, and there, my lord, they will examine as per this appendix H1. And if they come within the zone of consideration as prescribed in H1, they will be given the medical admission, irrespective of having a certificate under the statute. Because we are not going to cancel it. He can apply it for other jobs or other, my lord, studies and all, my lord, educational purpose. But for MBBS, my lord, he will have to appear before a medical board. That is the, my lord, entire purport of the, my lord, clause, my lord, 6.7 of the information bulletin, which is published by NEET, and we are bound to follow it. And we are following it, my lord. Now coming to the H1, my lord, there only, my lord, this H1, my lord, appendix have been mentioned that it will have to be as per H1. Otherwise, my lord, wherefrom we have come to know that, my lord, it is H1 appendix which will be required to be followed in, my lord, MBBS, my lord, admission. It's from that, my lord, the information bulletin. And as well as in the admit card also, it was at the very inception when they, my lord, appeared before the entrance examination. In the admit card, it was mentioned. Even in the result score sheet also, it has been mentioned that you will have to appear again. And that has not been put to challenge, my lord.
No, he has appeared.
Yes.
Or he or she has appeared.
No,
Petitioner
regarding that point, my lord, that we have not challenged that, my lord, particular.
that's a
disability
different
certificate.
issue.
That argument won't sustain.
But what happens to
Now-
H1?
yes.
Have you
Now,
applied
Lordship will-
H1?
Yes, yes. My lord, applying H1, it has been, we have stated in para 5, my lord, of our affidavit. We will have to follow that. Now, Lordship will see what has been prescribed in respect of visual impairment in H1, page 135. 135, my lord. Visual impairment, my lord. Blindness and low vision. So here he will come under low vision because his, my lord, disability of so far as power is concerned, as per their own certificate, as well as the, my lord, authorities in GMC, it is only -2. I myself have my lord, minus 3.5 in both eyes. So only -2. And her disability is 40%. Now, Lordship will see eligible for medical course, not eligible for PWD quota. Here it says, my lord, less than 40% disability. So, my lord, 39 and below, not 40, less than 40. Now, my lord, in the column, not eligible for medical course, it says equal to or more than 40% disability. So, it will have to be 40 or above 40, not eligible for medical education. Now, my lord, that note, my lord, down below, the star is there, my lord, down below. Persons with visual impairment, visual disability, Lordship will mark this word, my lord, of more than 40%. More than 40% means, my lord, 40.5, 41%, 42, anything. May I repeat, my lord, the line, my lord. Persons with visual impairment, visual disability of more than 40%, my lord. Am I, my lord, I been able to express, my lord? More than 40%, my lord. Because, my lord, in the chart it says equal to or more than 40%, means 40% or above. Here in the, my lord, note it says, my lord, more than 40%.
Then what happens to this 40%?
I don't know, my lord. We are not the author of this particular appendix H1. Lordship will see, my lord, for a moment, page 134. Page 134.
Yes.
Lordship will see the top. Board of Governors in supersession of Medical Council of India, amendment notification dated so and so. It is not issued by the government of Assam or, my lord, the Director of Medical Education by the Health Department. This is the authority who has conducted the entire examination, my lord, till today. Now it is National Medical Commission, that's a different thing. But same authority, my lord, has been changing from time to time. We are following that, my lord. And even otherwise, my lord, if a person, my lord, having -2 with the specs and all, my lord, power specs, how can he be termed as a disabled person, my lord? I can see clearly, my lord. It's not that I am a disabled person. I have -3.5.
My wife is -6, my lord.
My
That is
lord,
not the
that's
case, my lord.
That's why I'm
Case
saying,
is-
my lord.
Criteria has
No,
been given under
I understand, my
this
lord.
act, my lord, as to how to ascertain,
No. What he's trying to say,
my lordship. That I
that
understand, my
so
lord.
far the
If
disqualification under
If-
appendix H1 is
if the-
concerned
my lordship,
for the low vision, less than 40%,
if-
you are qualified,
my lordship,
but you will not come under PWD quota.
my lord.
40 and above, you're disqualified. Now, proviso says that persons with the low vision
Equal to
of more than 40%.
more than 40. If this argument has to be accepted, my lord, the entire PWD, this beneficial legislation will get, my lord, frustrated.
My lord, and one more thing, it says, my lord, next line may I continue, my lord. The person with visual impairment, visual disability of more than 40% may be made eligible to pursue MBBS course. MBBS course, my lord, not under PWD quota. And may be given. It's nowhere says that, my lord, will have to be given or shall be given.
No, do it further on.
Subject to the condition that the visual disability is brought to a level of less than the benchmark of 40% with advanced low vision aids, such as telescope, magnifier, etc. So that's
So
what.
was this applied to the petitioner?
Yes, my lord. In fact, my lord, considering this, my lord, ultimately we have found a disability will be 40% only, my lord. They will have to give a view that, my lord, after using the magnifying or any other machine, my lord, or the technology, if it can be brought down to 40%, below 40%, whether she will be able to pursue the medical course or not. In this regard, my lord, on the last occasion, senior counsel BT Corn has placed one judgment of the honorable apex court, which was passed on 15th of October 24. Not to this particular disabled category. It was regarding, my lord, regarding speech impairment, my lord. There also, my lord, same. Below 40%, fit for MBBS, but not eligible for PWD quota. Above 40%, not eligible for MBBS course. Eligibility part, my lord, under what percentage a person will be eligible under that quota, like in the, my lord, eye visual impairment, it is blank.
Let us see the judgment.
Yes, my lord, it's very relevant, my lord. In fact, my judgment copy was placed before your lordship on the last occasion. It is in the next item, my lord. Copy was furnished.
Before that, my lord, page 124 is the medical examination that has been done, my lord. Page 124 of the affidavit in objection.
It is, my lord, Omkar Ramchandra Gond.
124, my lord.
Omkar Ramchandra Gond.
So nothing is there, my lord, as to how this medical examination has been done, or whether any special aids has been used to see, my lord.
Lordship will see this judgment of the honorable apex court, everything will be clear.
Yes, let us see.
Yes. In fact, I am placing this for the benefit of the entire series, my lord, it will be helpful.
Citation.
Citation, no, not Omkar Ramchandra Gond.
Omkar Ramcharan Gond.
Lordship will see, my lord, para 2. Admittedly, the appellant has speech and language disability and is diagnosed with hypernasality with so-and-so, repaired so-and-so. The appellant is certified to have 45% in some reports. It was mentioned as 45% permanent disability as per disability certificate dated 18/5/2017. The appellant applied for a NEET UG 2024 for admission to MBBS course from the category of person with disability Act on 18 to 24. The application form had a disclaimer claiming which stated that the eligibility under the PWD category was purely provisional and was to be governed as per the National Medical Commission guidelines regarding admission of students with specific disability under the Right of Person with Disability Act 2016. The appellant appeared for NEET UG, next page, para 5, held on 5/5/24 and qualified the entrance examination. The schedule for centralized admission process, round 1 counseling for admission was notified on 28/24. The appellant applied for centralized admission process and claimed reservation under OBC and PWD category. In the provisional merit list published on 26/8/24, the name of the appellant figured in so-and-so number. Under the information brochure, candidates with disability have to submit a disability certificate issued for the year 24 and have to undergo medical examination at the Disability Assessment Board, like in our medical board. The appellant approached the designated disability certificate center at Sir JJ Group of Hospitals on so-and-so. The certification center certified that the appellant was physically disabled, physical disability of speech and language of 44%. In some reports, it was so-and-so, and recorded that based on the quantification of disability, the appellant was not eligible to pursue the medical course as per NMC norms. But in this case, my lord, in the apex court, he was not at all eligible because it was above 40. Even then, my lord, we'll proceed further. In view of that, the appellant was rendered ineligible person to obtain PWD reservation or to pursue medical course as per the NMC gazette notification. The Board of Governors of Medical Council of India, the previous avatar of NMC, has amended the Graduate Medical Education Regulation 997 by notification dated 13/5/2019. The existing Appendix H was substituted by Appendix H1, providing for guidelines regarding admission to students with specific disability under RPWD Act with respect to admission in MBBS course. As per the clause 1D thereof, person who having equal to or more than 40% disability were not eligible for medical course. The relevant clause of the schedule is extracted herein below. Lordship will see, my lord, the range of disability range. Eligible for medical course, eligible for PWD quota is nil. Like in the, my lord, visual impairment. Now, my lord, proceedings before the High Court. Disappointed but by no means dispirited, the appellant moved the High Court of Judication at Bombay in the petition being WBC so and so, contending that the Medical Council of India NMC is not empowered to lay down eligibility criteria in such a manner so as to altogether take away the benefit under PWD Act, challenging the notification dated 13/5/2019. In this case, my lord, the notification was put to challenge, but in the present series, nobody has challenged it. As well as the certificate issued by the Disability Certification Center. In the present series also, my lord, our report of the medical board has not been put to challenge, rendering him ineligible for pursuing the MBBS course only on the ground of disability exceeding 40% without anything more. The appellant also sought interim relief permitting him to participate in the centralized admission process in admission to MBBS course without considering the certification issued by so and so. Here, my lord, the High Court did not, my lord, pass any interim order. So he approached the Honorable Supreme Court. The para 10, running against time as the last date for submitting the choice for admission so and so. Since the result of so and so were to be declared on so and so, the appellant with great alacrity moved this court seeking urgent relief. Now in the interim order. When the matter came up on 2/9/24, this court, after hearing the counsel for the NMC, passed an order directing that the seat which the appellant would have been entitled, if rendered eligible, be kept vacant. This court also directed the dean, so and so Government Medical College and so and so College, Pune, to constitute a medical board consisting of one or more specialists having domain expertise pertaining to the appellant's disability. The medical board was to specifically examine whether the speech and language disability of the appellant would come in his way of pursuing the MBBS degree course. This course of action was previously adopted in another case so and so. Now, in the next para, my lord, the report has come, my lord, from the expert body constituted by the Honorable Supreme Court. In italics, it has been given. It stated that, my lord, that he will be, otherwise, my lord, suitable to pursue the medical course. It has been underlined. The board is of the opinion that the speech and language disability of the petitioner, namely so and so, would not come in the way of pursuing the MBBS course. Based on this particular, my lord, report, finally the Honorable Supreme Court held that he should be given the admission. Here, my lord, I also, my lord, say, my lord, considering all this, these are, my lord, this Honorable Court, or my lord, us who are representing the respective, my lord, parties. We are nobody experts in this particular field. Ultimately, we will have to bang upon a third party's report, if at all, because this is what the Honorable Supreme Court finally said. Lordship will see the conclusion. Internal page 39, down below there, the designations are there, my lord. 39 page. Yes, sir. Yes. My lord, here, my lord, one relief we would have, we hold that quantified disability per se will not disentitle a candidate with benchmark disability from being considered for admission to education institution. The candidate will be eligible if the Disability Assessment Board opines that, notwithstanding the qualified disability, the candidate can pursue the course in question. The NMC regulations in the notification of 13/5/19 read with Appendix H1 to pending the reformulation of NMC be read in the light of the holdings in this particular judgment. The Disability Assessment Boards assessing the candidate should positively record whether the disability of the candidate will or will not come in the way of the candidate pursuing the course in question. The Disability Assessment Boards should state reasons in the event of Disability Assessment Boards concluding that the disability a candidate is not eligible for pursuing the course. Well, here, so far as Lordship will see the point number 6, which will be relevant for us. Pending creation of the appellate board, we further direct that such decision of the Disability Assessment Board which give a negative opinion of for the candidate will be number 41, Roman 6, Roman 4, sorry, I'm sorry, Roman 4, 41. Pending creation of the appellate body, we further direct that such decision of the Disability Assessment Board which gave a negative opinion for the candidate will be amenable to challenge in judicial review proceedings. The court seized of the matter in the judicial review proceeding shall refer the case of the candidate to any premier medical institute having the facility for an independent opinion, and relief to the candidate will be granted or denied based on the opinion of the said medical institution to which the High Court has referred the matter. So this is what I want to point out. Otherwise, we have a report, he has a certificate. Now, which one will be, my lord, relied upon? How can, my lord, this honorable court decide, my lord? That's what I want to place, my lord. But, my lord, here time is running out, my lord. Only thing is, because in the rest of the cases, all are below 40. So, my lord, they will be entitled for, my lord, MBBS course, not under the PWD code. That will be my argument in the other series. Here, it's the case, only case, my lord, where it is 40%. And that, my lord, note given as regards the visual impairment. There, my lord, if a third opinion is taken that whether she can at 40% disabled depart to the medical course, like in the present case of the Supreme Court. Perhaps, my lord, that will help the entire issue.
But what is your suggestion for a third party?
But here, my lord, the GMC, my lord, as on date within the nearest possible, my lord, institution will be, my lord, the AIMS, my lord. But some central government authority will have to, my sending us will have to be there so that the direction can be given to constitute the board and to examine all these petitions. At least they can have a fair, my lord, consideration there and have a satisfaction that ultimately something has been given.
Do you have a name sent in the?
My lord, here, my lord, probably for AIMS, my lord, K. Gogoi, he used to appear, my lord, post of Gogoi. I only informed him that, my lord, if possible, to help this.
You have a branch here in the Guwahati.
Yes, AIMS, my lord, it is there, my lord. In fact, there is a branch in Guwahati as on that is functional, I think. Or, my lord, after GMC, I don't think, my lord, private institutions are there, but common, my lord,
My lordship, may I place one submission, my lord?
rest I leave it to your
Because-
lordship, my lord, regarding the final decision.
With regard to the notification, my lord, that my lord, equal to or more than part, my lord, this, my lord, the condition that has been, just my learned friend has submitted, that because it is 40% not eligible. Because in this particular note, my lord, more than 40% has been used. But if my lordship, that is again, my lord, page 135 for a moment, my lordship, if peruse 135, my lord, this equal to or more than 40%, low vision equal to or more than 40% disability, he will be not be eligible for medical course, but 40% below. Now, my lord, what will happen? My lordship has rightly put a question, what will happen to benchmark 40%? Because as per my learned friend, it has been more than 40%, 40.5, 40.10, 40. Now, my lordship may kindly see equal to or word has been used or more than 40% disability. So, if it is the word equal to is used, equal to 40%, then it will mean more than 40%. If word more than 40% has been used, then it will mean equal to 40% because word or has been used, not and, my lord. If word and would have been used, my lord, then equal to 40% and more than equal to 40% would have different standing, my lord. But in this particular case, or has been used. My lord, if this notification, 2019 notification would have been followed in letter and spirit, my lord, then there would have had not been any need for us to come before this honorable court, my lord. But this notification has not been followed properly, my lord. According to this notification, my lord, what was the procedure so far as their own bulletin is concerned, my lord? First, we apply under PWD quota on the basis of PWD certificates. Then, my lord, if we get selected, then prior to first counseling, my lord, online counseling, we need to go for a medical examination. Then, my lord, results comes out. My lord, the institutions are allocated. Then, my lord, the certificates on the basis of which we have obtained, my lord, the pass the exam and get eligible for, my lord, admission. Then those during the admission time, those examination of those certificates was given in the notification, my lord. But in this particular case, my lord, because notification does not say that you put a candidate again to medical examination without taking into consideration the earlier PWD certificates which was issued to a particular candidate by a competent authority. The notification says, my lord, there is a PWD certificate. On the basis of that, admission has been given. If a candidate succeeds in the examination, then my lord, see as per the notification whether if 40% disability, whether by use of applying advanced low vision aids, if visual if a case of visual impairment, she can be made eligible to admission, or if a locomotor case, then by using my lord the assistive devices, she can be made eligible. And if she passed that stage, then at the time of admission, you verify those documents, those PWD certificates. But this particular case, my lord, in all the cases, my lord, in presence of PWD certificates on the strength of which, my lord, they have been given admission, which they'll again verify at that time of, my lord, giving them admission, subject them to re-medical examination. And in this particular case, my lord, or has been used, my lord, not and, my lord.
So what this court is suggesting
My
is
lord,
that in terms of the directions of the Supreme Court,
my lord.
we can go for an independent opinion.
In this particular case, my submission would be, my lord.
Are you not willing to subject yourself to an independent
I-
opinion?
Yes, my lord, but my lord, in this particular case only. Other cases, I'll put my submission.
That is I'm on this case only.
Yes.
I'm not
My lord,
getting into the other cases.
my lord, in this
Like Gogo
particular
has
case,
already, these are all below 40% other cases.
again, 40%, two opinion, my lord, both the opinions 40%. Third opinion again comes 40%, my lord. Because that is their board, they are saying 40%. I'm not challenging that, my lord, that I'm not a 40%. I'm 40%, my lord.
Yes. Gogo, can AIMS conduct an,
Lossy directed, then I'm scan lossy, lossy directed.
you have all the specialists?
Lossy.
Member লাগিব as per disability act.
আছে এইবিলাক বাত হৈছে
Disability.
Sorry to interrupt. In terms of this judgment, Stumkar case, your lordship will see that only the AIMS is the competent authority who can conduct the test in regard to certification.
Where is that mentioned?
Yes, well, your lordship will look at
Side page.
because my case is different because I already have a certification from AIMS. I'll just point out the relevant paragraph. মোৰ laptop today. Just liquid knowledge. I'm just pointing out. Your lordship will kindly look at page 25. Just a moment. Your lordship will see paragraph number, it starts from
34.
Page 21, the communication. Malab, this is the communication which the National Medical Council and the state government has been aware of. Your lordship will find that communication start from page 22, paragraph 34 at page 22. Your lordship got it. Malab. Page 34 or 22, paragraph number 34. We commend the Union of India for having issued the communication dated 25/1/2024 through the Ministry of Social Justice and Empowerment. We also deem it appropriate to extract the communication. The entire communication has been extracted. Now, if your lordship goes to the bottom of the table, your lordship will find at the last column row 7 at page 26. Your lordship got it? All India Institute of Medical Sciences at all places should be designated for issuing certificates of eligibility for attaining medical No, I gave it my lords. The table last part I have last.
I'm on that.
Yes. All India Institute of Medical Sciences at all places should be designated for issuing certificates of eligibility for attaining medical education. In item number 71, I already have all those certifications when item number 71 will be called. Now, what has happened, my lord? Your lordship will find that the court took note, this Honorable Supreme Court took note that this is a communication of 25/1/2024. So now the state cannot say that it will not comply with the notification or they are not aware of it. But even then the Supreme Court said that those who have not complied it, it is expected that they will comply it from before the academic session of 25/26 that your lordship will find in the next paragraph. We have no reason to doubt that the National Medical Commission will expeditiously comply with the requirements in the communication of the Ministry of Social Justice for Empowerment dated 25/1/2024. In any event, we direct the needful to be done by the National Medical Commission before the publication of the admission procedure for the academic year. So it doesn't say that it will be not followed for 24/25. The outer limit is 25/26. Now your lordship will see one more relevant paragraph. Just a moment. The paragraph number 50, your lordship will see. I think your lordship has already said it, but your lordship will look at paragraph number 50. Paragraph number 50 of the judgment. In paragraph 50, my lord, so far the state of Assam is concerned, my lord, the Assam does not have a appellate body. So the power of judicial review is always there. That way your lordship will get at paragraph number. Pending creation of the appellate body, we further direct that such decision of the Disability Assessment Board, here it is the medical board, which is my learned friend is there, which give a negative opinion for the candidates will be amenable to challenge in judicial review proceedings. Now you cannot say that just because I have given some expert have given a negative opinion, that's why the power of judicial review is not amenable. Your lordship will see. The court sees that the matter in the judicial review proceedings shall refer the case of the candidates to any premier medical institute having the facility for an independent opinion, and the relief to the candidate will be granted or denied based on the opinion of the medical institution to which the High Court has referred the matter. Well, so far these matters are concerned, except item number 71, where we have the opinion of the All India Institute of Medical Sciences, because we came to know that it is the All India Institute of Medical Sciences the only competent authority. In other cases also, I have another case where I have a locomotor disability. That your lordship has to refer it to the All India Institute of Medical Sciences, Guwahati, to do the needful test. If it, the Guwahati doesn't have, they have to get it from All India Institute of Medical Institute, Delhi. Because the court doesn't want it to rely on the GMC or any other medical institute. In Delhi also, the Maulana Abdul Kalam Azad College or the Lady Hardins or the Vallabhbhai Patel, they know. So the court has said that it is the All India Institute of Medical Sciences. All these cases, other cases, except item number 71, if it is below 41%, then your lordship may have to refer it to the All India Institute of Medical Sciences, Guwahati, which is an institute which has all the facility. In my case also, I thought that some of the facilities were not available in GMC, but it was available in All India Institute, because my 71 item is a case of thalassemia. So thalassemia, the tests were required to be done in All India Institute of Medical Sciences. And if All India Medical Institute doesn't have the facility, then your lordship can direct to have the consequential examination by a reputed laboratory, say Dr. Lal and all those. But you can, it's not that you can't do it from a private institute. Suppose the All India Institute of Medical Science may not have particular, then you can get it done from Gangaram or Apollo Hospital. Those are allowed. That flexibility is there. So other cases may not. That's why in the first day when I moved the petition, I thought that the disability certificate once issued under the Physical Disability Act of 2016, nobody can question it. But now it appears, my lord, after going through all the notification, I have made a compilation of the notification. Your lordship may kindly look into it from copy to the son office.
Anyway, that is will they
Yes.
take up?
Yes,
case
but
by-
so far item number 71, I will respectfully submit. Your lordship will not may not have to refer it to the All India Institute of Medical Sciences, because I already have the certification of the All India Institute of Medical Sciences and the document to show that they have ignored my what they have, because my case was that they have said that I have a HBE disease, which is anemic only. They have ignored my thalassemia, that I have a beta positive thalassemia, which is under the intermediate. From their own documents, I will show that they overlooked that, and it is already written that I am a case of intermediate thalassemia, and I have those certification from the All India Institute of Medical Sciences also. So my 71 case may not be referred to the All India Institute of Medical, that your lordship will take a call today. And so far the other cases are concerned, your lordship has to refer it today, because after going through Omkar's, because it was, as an officer of the court, it was my duty to point it out of that Omkar's case. That's why I pointed out. So under the Omkar, your lordship has to refer it to the specialized medical board, and that will be the All India Institute of Medical Sciences. And if this doesn't have the testing for some, then they have to do it through a reputed laboratory, but not GMC or AMC, because they have all, because here what I find in item number 71, the officials are now trying to, more than giving benefit of the act, they are now trying to deny the candidate the benefit. So that trust has gone, my lord.
My lord, one thing, my lord, if he is speaking about trust, my lord, the candidate wants to study in Assam only, my lord. He must, my lord, know this. No. This sort of submission will not.
I'll point out from the 71 document, my lord. When I took a call on the day one, your lordship will recall that I said that hematologist was not in the board. No, so please pardon me. It's not that everyone is not beyond above suspicion. Now, on the day one, I took a plea that hematologist was not there in the notification. Then later on, they came with a separate order, which is only that hematologist was appointed. Okay. Then when I said that you have not conducted this test, only in item number 71, after I filed the writ petition, they again constituted a reassessment board to review it, which is not there in the other cases, because they knew that on day one, they had not examined it. So these are the loopholes. They were trying to fill up the loopholes by the second, I came before this court in the first week of September, and 30th September, they tried to again review it after filing of the writ petition. So in other cases, you will not find. And even in that review assessment board, I will show it from their own document how they have overlooked that I'm a patient of intermediate thalassemia, which is a 40% benchmark disability. So he's making a bold statement, and which is applicable to all, that my benchmark disability is less than 40%. That I will not agree with my learned friend, and I will show it from their own documents and the reports which they are relying.
Let the item 71 we call, my lord. I will make my submission.
My lord, with regard to item number 70.
So in regard, my lord, here, my lord, two para I would like to point out, my lord. Para 34 of the judgment, lordship may carry. Just now, my lord, it has been submitted that, my lord, Honorable Supreme Court has said that it should be the aims, my lord. All India Institute of Medical Science. It's not that, my lord. Page 34, one line only, my lord.
71 or 4.
Page 22.
Mine is 71.
We commend the Union of India for having issued the communication dated so 25/1/24 through the Ministry of so. And it has been quoted, my lord. That communication has been quoted. It has not been implemented. Lordship will see page 25 after the chart. It is a part of that, my lord, quoted, my lord, part, my lord, of the communication. In view of the above, NMC DGSS is requested to take appropriate action, and the report may be sent to this department, inverted comma close.
That part.
That's how, my lord, one can make a submission that, my lord, Supreme Court had passed an order, my lord, that it will have to be applicable from this year itself. No way, my lord.
No, part 35.
In fact, misconstrued, my lord. I'm telling that I'm subjecting myself to the All India Institute of Medical Science. That nobody should have nobody should have objection to that. So I have voluntarily said that in the other case, I have locomotor disability. I have a benchmark disability of 40%. They are saying it 14%. That 41 they had made it 14. So I said that let us go and look into, because locomotor disability, AIMS has all the orthopedic department and all, so they can do it. In case of thalassemia also they had it. I have gone and taken the certificate. So I'm saying that AIMS has all the infrastructure. It is a full-fledged institution. They have admitted candidates for MBBS course as well as PG in Amingao. So AIMS is the competent authority, and many of the professors have now been doing their job in AIMS and all. We have many cases. Earlier also many cases the opinion of the AIMS was taken. So AIMS is the competent authority, and we are all amenable. So far your lordship will direct, so far GMC and AMC is concerned, I have objection. So far my items are concerned, because I'm going to AIMS. And now they can't say that AIMS will be biased towards them and will be favoring me. That's not the case. So I'm amenable to the proposal that so far locomotor disability, my candidate is concerned. I will get myself examined at AIMS. If AIMS says that I don't have that benchmark disability or that, then I should, as an officer of this court, I should not allow a person to enter into an institution under this disability quota and defeat the salutary objective of this act. That can never be my submission or my objective while arguing for a writ petitioner.
May it please your lordship. My lord, with regard to this particular case is concerned, my disability is 40%. The medical board has assessed my disability to be 40%. So there is nothing, my lord, on my part to disbelieve with regard to 40%, sending it again for re-medical examination before AIMS, my lord. I'm sure this 40% will come. Only, my lord, if my lord,
No. What what this court is intending to do is let an independent body
my lordship,
examine you strictly in terms of appendix H1.
Yes.
Strictly in terms of appendix H1, insofar as low vision is concerned.
my lordship,
So therefore, what the GMC said, what they have filed in the affidavit, that is
affidavit,
that is a different.
they have said 40%.
That is,
And as
But-
per the notification, my lord,
once the independent body
My lord.
examines you
my lord,
in terms of this annexure H1,
my lord, in terms of the other candidate is concerned, my lord.
I'm not talking about the article.
My
Let
lord.
us consider it on your one of the
One
time
petition.
is running short.
Yes, yes, my lord.
I have to
Yes.
pass in order.
Yes, yes, yes. This case, my lord, the 40% benchmark disability has been, my lord, identified by the respondent number 4 medical board.
What you are saying is that the GMC also has found that you have 40%,
40%,
correct?
my lordship.
But they have not applied the proviso provided under annexure appendix H1.
My lordship,
Let an independent body conduct the inquiry, conduct the examination.
whether it will come below 40%
That,
or not
that
after
we are
applying,
not speculating anything.
my lordship,
When I say an independent body, this court is not speculating anything.
my lordship.
We expect that the independent body would come with the appropriate result. That's what I'm saying.
But what I'm submitting, praying for before this honorable court is that, my lord, when this on from perusal of all the records, my lord, when my disability has been ascertained as 40%, my lord. My
We
lordship,
GMC 40, competent authority 40,
my lordship,
but you are saying annexure H1 has not been followed by GMC.
my lord,
Correct.
my lordship.
Let the independent body consider it in terms of H1. That's what I'm saying. Are you afraid to appear before the?
No, that's not there, my lord, because in one of my case, my lord, I have a certificate from the,
No, these are different cases. Let us not go from one, jump from one here to other. Let us concentrate on one particular case, dispose it off, go to the next case.
my lordship,
There's no time.
my lordship. Oh, I know. My lordship, I agree to that, then, my lord, because whatever my learned friend is suggesting, the honorable court is suggesting, my lord. I have to abide by it, my lord. My only submission was that this notification was not issued. Then I'll
Let it be done within a day or two. Can
My
you do
lordship.
it?
That is what
Because see, time is running short in the sense today is Monday.
Monday.
Thursday, Friday is a holiday.
Thursday, Friday is a holiday.
Yes, Monday is 4th, 5th is the last day. So supposingly if some seats are left out, if they will come within the zone, they have to
But
admit it.
Rosiba gives some time. I tried to connect the director of the AIMS Lordship, but he's not pick up the phone. Lordship. So Rosiba,
Because of the
Lordship
time
direct-
constraint, my lord, I'm worried.
Lordship directed.
Lordships gives a
If
direct
Lordship
aims
direct-
to do it.
Yes,
Yeah,
aims to
earlier experience is there. Malad.
If Lordship
You'll have
You
to
can
do it.
pass a common order in all the cases instead of passing individual order. That except item number 71, I will put my arguments separately.
Except there is another item wherein, my lord, there is a certificate issued. I'll place when that particular case comes up.
Can we dispose it with a common order?
That will be
Your
more.
lordship cannot dispose it. Your
Pending,
lordship
my
has to await the or
No,
report
not
of the.
dispose, my lordship will give a date and time, my lord, when.
No, I'm not saying disposing.
yes,
I mean,
Days also.
what's the direct?
Days,
Yes,
in that
yes.
line it can be.
Except item number 71, I will make it a submission. Your lordship will consider. I'll be as brief as possible.
Item 75, my lord, I'll take 5 minutes of your lordship. Other, my lord, by applying 2019 notification, my lord.
75 to piece of 71 to
Prabhu, mutu log daga.
I think 71 If my friend agrees, because otherwise it's 335 only. We have to be considered to the other councils also who are waiting for their, to do their cases before vacation. So I have.
Unfortunately, today I had some
That, my lord,
unexpected,
yes, my lord.
what you call,
We can't.
something happened.
Yes, my lord.
That is also disturbing my mind. Anyway, I have to settle down. Because that thing cannot keep on lingering this side. I have to see into this also.
So the others, my lord?
75. May I place my lord?
71 to Kollam.
Pankaj, মোৰ laptop টো দে। I'll be as brief as possible, my lord. My lord, your lordship will take up the writ petition, page 20, direct.
Yes.
My lord, at page 20, your lordship will find that she is a case of thalassemia and she has 40% benchmark disability. Page 20. Now, this has been issued by the competent authority, respondent number 3 and 4. But even if I have a certificate, after reading Omkar's judgment and the earlier judgments of the Honorable Supreme Court, insofar in case of medical admission is concerned, as on today, in view of the notification of 24 of the ministry, the AIMS is the premier institute which can only give the certificate in regard to medical admission. So it's now no use arguing before your lordship that since I have a certificate from the statutory authority, that's why I should be considered and they cannot sit as an appellate authority before this. That is not the law. Then your lordship will find that page 21 is my disability ID card, which has also said it is 40%. Now your lordship will find at page 26 now.
Yes.
Page 26 is the admission notice of 29 August 2024. Your lordship got it? 29 August 2024. These are the provisional candidates selected under the PWD category. And my name appears at my lord serial number 29, my lord. Page number 29, my lord. Your lordship will find 3031 Drishti Bora. Page 29, my lord.
Yes.
Yes. Drishti Bora, unreserved, PWD, and Tinsukia Medical College. So I appeared, I was provisionally selected to go and appear before the Tinsukia Medical College. Now at page 31, on 6th of September, this is the admission notice which came out for the PWD categories. I don't find my roll number. Prior to 6th of September and prior to filing of this writ petition, there was no communication, no reasons given why I am not selected under this PWD category. Your lordship will kindly look into my specific pleadings at paragraph page number 9. Because a submission has been made by my friend that we have not challenged the medical assessment board report. That's why I'm pointing out, pilot, your lordship will find. Paragraph 8 at page 9. Your lordship will look at the bottom line of paragraph 8. However, the petitioner has not been provided with a copy of the verification report dated 5/9/2024, and as such, the petitioner is in dark as to reason why for rejection of her candidates under the PWD Divyang category. It is pertinent to state here that no medical test was conducted by the medical board during the verification of the disability status of the petitioner. Then your lordship will look at paragraph number 11 also. Just this last paragraph, I will be referring to the pleadings. Page 12, paragraph number 11. That the petitioner respectfully, paragraph number 11, that the petitioner respectfully submits that she has not been informed the grounds or reason for the rejection of her candidature. Further, no copy of the PWD benchmark verification report dated 5/9/2024 mentioned in the admission notice dated 6 September 2024 has been furnished to the petitioner. As a result, the petitioner has been arbitrarily kept in the dark regarding the grounds or reasons for rejection of a candidate. Since I don't know the grounds of rejection, how do I challenge it? Then after filing of this writ petition, the grounds were mentioned in their affidavit in opposition that your lordship will find in the running page at page 61. Page 61, running page is page 61. Now it is a running page, my lord. I think your lordship's page is marked. In affidavit in opposition, my lord. They have
Yes.
page 61, your lordship will find. After due examination of the disability status of the petitioner by verifying the lab reports and other documents. These lab reports and documents were
Where
furnished.
you are reading from?
Paragraph 61, my lord, third line.
Okay.
After due examination, your lordship got it? After due examination of the disability status of the petitioner by verifying the lab reports and other documents furnished by her, came to the finding that the disability of the petitioner is below 40%. The petition, then be it mentioned here in that said decision of the medical board wherein the petitioner disability has been found to be below 40%, thus holding her ineligible for admission into the MBBS course 2024 under the disability quota has not been put to challenge that. I didn't know it. This is the first time I have come to know. Then your lordship will say. However, despite being found to be not eligible for admission under disability quota, the petitioner has since approached this honorable court by instituting the present writ petition. The medical board on 30/9/2024, that is after filing of the writ petition, this is the only case, my lord, where the medical board again reviewed the disability status report of the petitioner and came to the following finding mentioned herein. That this I will take your lordship to the report, but even then your lordship will see that I'm not disagreeing with this finding, which is quoted below. Mutational study is a confirmatory test for diagnosis of hemoglobinopathies. According to the molecular studies of the index case submitted by the candidature Dishti Bora, so and so, she has HB. Your lordship will take note of this word, HB. It's one of the traits of hemoglobin, E trait, my lord. Your lordship will say. And homozygous state. My lord, what has happened in thalassemia cases, we take the traits from either of the parents or both the parents. If it is hetero, means if I take one of the trait from either of the father or the mother, then it is not severe. But when it is homozygous, that means I take the trait from my mother and father. So it says homozygous. This word also your lordship. On 11/3/2020, which makes a final diagnosis of HBE disease with immune hemolytic anemia. So this, as per this finding of the medical assessment board, I have immune hemolytic anemia disorder. That I am not disagreeing because it is an expert body. But what I am disagreeing is the same medical report for coming to this finding has been ignored, where I have been categorically shown that I am a patient of thalassemia beta variant, which is an intermediate. I will come to that report now directly, my lord. Your lordship will kindly go from here to page 85. Your lordship got page 85? Your lordship got page 85?
Yes.
Yes. Now you see provisional diagnosis. This is lab report 31/1/2019. That means this is the lab report which was furnished by me to them. And your lordship will find that lab report at 128. They have not given this lab report in their affidavit in opposition. I have given this lab report, which is referred as 31/1/2019. Your lordship will find HB genetic sequencing. Genetic sequencing is, my lord, suppose we have a disorder of genetic disorder of thalassemia. It will not change with age. That the genetic disorder will remain. Only in case of thalassemia, what has happened earlier in 2000, earlier period, my lord, the blood transfusion was required. Now some steroids and drugs have come, which is not required to do the transfusion. The GMC authorities have said that since I don't have blood transfusion from 89, so I should not be considered under the thalassemia intermediate category. But that has been now clarified by the subsequent medical examination that if you take drugs, then if you are not dependent on transfusion, then if I stop this drug, next month I will have to take transfusion. So this taking of transfusion is not the correct indicator. As per the 2024 guidelines, I will show to you. Now you also will see this lab report which they were referring at page 128, my lord. This is the lab report which they are referring, my lord, which I had given, my lord. of a reply. Your lordship got. Now your lordship will see at the top, reported on 31/1/2019. Your lordship has seen. Now your lordship will see this is the test done. HBB gene sequencing for mutational analysis. But this is the test normally which is done to detect abnormality in case of thalassemia. Now, if your lordship looks into the result, my lord, interpretation your lordship will find.
See, Mr. Conrad, there's no point reading this.
Yes.
I don't understand anything.
No, but normally why I was trying to say, because as per this report, I have this B positive, that is thalassemia intermedia, beta, which they have ignored. They have taken into consideration my anemic data, but they have ignored this thalassemia intermedia measure. And in terms of the guidelines, if one is detected to be have thalassemia intermedia measure, then I fall within the benchmark of 40%. Then what I did, my lord, your lordship will next look into the document that in terms of the Omkar judgment, I approached the AIMS. The AIMS report is at page 140.
Yes.
Now your lordship will only take one note. Patient reviewed, case of beta thalassemia intermedia, genotype B+, beta positive. Then your lordship will next look at page 142. This is the recommendation of the AIMS. AIMS said that do the comprehensive LB thalassemia panel by NGS. This is the genetic sequencing. Now, in terms of this AIMS direction, I did the lab report that is at page 151. Huh? 151, your lordship got it?
No.
The new 151.
Is it in your reply?
Yes, additional affidavit. 151.
Yes.
Your lordship will find at page 151. Now my condition has in terms of AIMS, my condition has deteriorated. It has become now thalassemia major homozygous.
Where is that?
151, my lord. The variant detected, genotype, allele status, clinical significance is thalassemia major. And this Gangaram, which report was of 2019. Now Gangaram has also clarified at page 154, your lordship will see. So if I stop the medicine, sometimes it goes to thalassemia major, sometimes it comes into thalassemia intermediate. Now diagnosis, your lordship will see at page 154. HB with HBFS, thalassemia intermediate. Then hemoglobin, then your lordship will, but just to hemoglobin is better. Plan to take off azoran. Azoran is the drug which I am taking to reduce my blood transfusion dependent. And who has given this certificate? Dr. Nitin Gupta, MD, DM, Clinical Hematology, AIMS, New Delhi. Now I will take your lordship directly to the guidelines. Copy of the code. I have annexed all the guidelines just from 2017 and all, but to cut short, this is the 2024 guidelines, which is holding the field today. Now your lordship will see at page 77. Your lordship got page 77. Yes. Now your lordship will see the disability caused due to blood disorders. 3 are there, A, B, C. I fall under B, thalassemia.
1 minute.
So page 77.
Yes,
Last.
yes.
Disability caused due to blood disorder. B is thalassemia. Then your lordship will turn into Now your lordship will see the background. My lord, just I'll read one paragraph, then I'll take you to the lordship. Background, my lord, at the bottom. The inherited blood disorders at present covered by the RPW Act 2016 includes hemophilia A or B, thalassemia major and homozygous sickle cell disease. All of this lead to serious and permanent health problems that are progressive over the person's lifetime. The persons with these disorders have a permanent disability that can lead to adverse complications and are progressive. These persons require lifelong treatment to survive and manage their disease. With good treatment, some improvement in the symptom burden will happen, but even with good treatment, complications because of the disease or the treatment will still occur. They require regular checkups and it adversely affects their educational pursuits and employment. They need family support to avail the essential treatment on a regular basis. Even with the standard of care treatment available in India, all persons with blood disorders will experience limitation because of the disease, suffer the risks of complication and reduced life expectancy. Hence, benchmark disability of 40% is assigned to the patients fulfilling the diagnostic criteria of severe hemophilia, thalassemia major, homozygous sickle disease, and so on. So for anyone who is having thalassemia major or intermediate, their benchmark disability will be 40%. In Gangaram's report, I was intermediate. When the test was done at the AIMS, my condition became worse, it became major. Now, your lordship will see the next line. Hence, my benchmark disability of 40% is assigned to the patient fulfilling the diagnostic criteria of severe hemophilia, thalassemia major, homozygous sickle cell disease, and severe forms of compound heterogeneous sickle cell syndrome, sickle bed, thalassemia, and sickle HBD. The terminology, this is important, the terminology transfusion-dependent thalassemia, TDT, and non-transfusion dependent thalassemia is currently being used by most hematologists. All the disabilities are not related to transmission alone. This is important, madam. All the disability are not related to transmission alone. And these terms may not be used by some not familiar with this terminology. Hence, we kept older terminology as well. The disability is deemed to be permanent, hence a certificate once issued should be valid till a assessment is requested by the patient or medical authority, which will be necessitated when the patient receives a curative treatment like gene therapy, gene editing, or hematopoietic stem cell transplant, or when new novel drugs became. The drug which I was referring at page 154 is the drug I am using. It's a steroid, very heavy dose. But because I'm using the drug, I am now no longer dependent on transmission. Now, so far, dear lordship, will next go to page 81. Page 81, your lordship will find at the bottom, thalassemia major and intermediate, the heading. Now, it explains the disorders. Now, if your lordship turns the next portion, next page at 82, your lordship will find in the bold. For disability certificate, the patients of thalassemia major and intermediate qualify by benchmark disability of 40%. So, since I already have a intermediate thalassemia and my condition has worsened now, and the AIMS have, because they are relying on a 89 certificate. Now, AIMS has said that I am a thalassemia major. And in the Gangaram also, it has clarified that I am, since because I am dependent on that particular steroid drugs, that's why I'm in the range of intermediate. This varies, my lord. Today, I'm taking the drug. If I don't take that drug, then on the next month, if my blood test is done, then I have to do a transfusion. Then I cannot advise a person to cut off his hand and say that you get yourself admitted in a locomotor disabilities or you will risk your life by not taking this drug. So, so far this 72 item is concerned, I already have a certification from the appropriate authorities, and it prima facie shows that when the medical reassessment board, when they considered my certificate, they have ignored my certification of thalassemia major beta plus, which is an intermediary variant. That's why I said that this is not a case where your lordship will wait for the result, because prima facie the AIMS authorities and even the Gangaram doctor, he is also a patient doctor of AIMS Delhi, have certified that I have a thalassemia intermediate with sometimes with variants of major also is there. So I qualify under the benchmark disability of 40%, and that's and I'm not saying that their assessment of enemy HBE that I don't have. I said, but I have consulted the doctors also that these two diseases can coexist as per the medical reports which are there. And it has said also that I have a HBE, that anemic condition as well as thalassemia condition. And in the affidavit, there is no specific denial that I don't have a thalassemia major intermediate. They say that on the basis of this report of 2019, I have only anemic. They have not said categorically or specifically that I don't have thalassemia major or intermediate. That's why they have done this reassessment of my case after filing of this writ petition, which is absent in the other cases. That's my humble submission. So for this case, your lordship can separate from the chef, my lord. I need not burden my lordship with the judgments and all. In the Omkar judgment also, it has referred in one paragraph that the attitude of the government should be to give the benefit rather than to deprive. Once you commit a mistake, but admit it, that you have failed to look into this thalassemia measure and the intermediate criteria, because it is the future of these students whom you are dealing with. We should not have any ego issues to say that you have only a HBE variant, whereas the same report says that I have a thalassemia intermediate case.
My lord, so far as the new reports, which have now, my lord, been placed in the form of an additional affidavit, as well as in the affidavit in reply by the petitioner. She appeared on 9th of October 24, not, my lord, pursuant to the Honorable Court's Supreme Court order, because that came in 15th of October. Just I'm clarifying. But she has approached, she has a report. But, my lord, these are medical diagnosis report, not issued by some hematologist. So let her appear before the AIMS authorities. They will say she's 40% or 50%. She may be above 40%. That report is not yet before the Honorable Court.
No.
There is no such certification, my lord. That is 40%.
Page at 136, I appeared before the AIMS.
No, that's why. Where is that?
This
40%?
is the hematology. I have the gene report. This hematology is this thalassemia is a case where if I do.
Saying, my lord, where is the report? Then it is.
But I have done the report
Let her
in terms of
appear.
the
I'm
AIMS
not saying,
direction.
my lord, she is not 40%.
No.
With this report, she can appear before the same authority.
No, you have
They
to
will
be-
certify it.
see-
Yes, it is 40% disabled. How can this Honorable Court assess, my lord?
No, your lordship will see.
Lordship will see the certificate, my lord, whatever document he has placed, let him indicate where it is written that it is 40%.
No, 40%.
These are diagnosis report.
No, 40%
What is
will
the
be,
view
no, so
of
my
the authority?
landlord friend has again gone wrong where, just a moment, go, Mr. Bogut.
I am countering to what
40%,
he has
no
said.
doctor will give you, that this is 40% or
That's why before
30%
the
or
board he will
25%
appear.
in case of thalassemia. They will say whether it is thalassemia, intermediate or major. If it is intermediate or major, in terms of the guidelines which I have referred now, it will be a benchmark disability of 40%. No doctor or institution can give that she is a 40% or 30% or 60%, unlike in case of other disease. In case of thalassemia, it is only the indicator is, my lord, your lordship will see at page 136, my lord. It is the hematologist department where I have gone, my lord. Because I am running against time, my
No,
lord.
I am not saying, my lord,
But
if your
page
lordship passes an
136,
order, I have
but-
nothing to say.
But
But my lord, there will have to be a certificate.
No, I'm showing the
indicating that
certificate.
it is
Just
40%.
my lord, your lordship will see the 136. 136, your lordship will see. Where hematology department, my lord. Hematology, they have recorded this. Then they have directed that they have at page 140, they have given the observation. Case of beta thalassemia intermediate genotype B+B+ at page 140. And you at top your lordship will find it is the hematology department, 140 hematology department. Case of beta thalassemia intermediate genotype B+B+. Then your lordship will see at 142. Even then the doctor asked me to do this comprehensive beta thalassemia panel by the NGS. NGS is, my lord, next generation sequencing at 142. Huh? And gene sequencing, that report, your lordship, I have already referred.
No, that's fine.
Yes.
That's fine.
And that 40% benchmark, your lordship will look into that. And this,
Oh,
that, if I have an intermediate measure, it is 40% they have to do. How can they say that they will not rely on these guidelines at page 82? My lord, your lordship will see at page 82.
My lord,
Once
we are
again.
the authority who will give the admission. We are not the authority who will give the certificate.
No, you
That's what
don't
I'm
have
saying,
to, my lord. You
I am
don't have
appearing
to.
for the
This is the
director of
case.
medical education, my lord.
My lord, it is the case of
Why
the.
he is signing off, my lord?
No, it's not a question of
She
science.
will definitely get.
My lord, your
I'm
lordship
not
will
saying
look
that,
at
my lord,
page
she should not
82.
get. She
My lord,
must
page
get if she has
82. My lord.
40% disability. my lord.
Well, page 82, you all say,
will
for the
appear.
purpose of disability certification, the patient of thalassemia major and intermediate qualify for benchmark disability of 40%. This is your own guidelines, my lord. The guideline starts at page, my lord.
That I
Considering the
see.
guideline,
That
my
I
lord,
see.
how can this honorable court say, my lord?
As per the guideline,
Yes.
you qualify under the 40% thing.
And that is what is required.
So what this court is suggesting,
Yes,
why not you also go
along with this
Well,
report,
I have
my lord, she will
already
indicate it.
examined myself in the AIMS.
no with this report.
Final report.
With
she
this
has not
report,
appeared.
you go
But-
before
but,
the independent body,
Yes.
and then what they will do, they
Yes,
will
yes,
give
my lord,
you a certificate of
But so
40%.
far, like in the other cases, in thalassemia cases, we have consulted the various doctors. They cannot certify as 40%, 50% of it. They can only say whether I am thalassemia intermediate or major. They cannot say the benchmark disability of say 40% or 50% or 55%. They can say, if they say, just in my case, they have said it is intermediate or major. I can again
Let
go
us
and
see.
appear. I have to just was
Let us
the-
see the benchmark for thalassemia.
that your lordship, I have just referred that page.
No, that part I've seen.
Yeah, that in the original notification.
Ah.
Okay. H1 I'm showing it, madam.
Page.
Madam, page 30, it started page 34.
Hmm.
Compilation. Your lordship will find it. Just a moment, madam. At page 37. H1, my lord, that H1 I have compiled it for your lordship's
Oh,
convenience.
this book.
Yes, page 37. Because my friend was referring that day to so many notification. It's very
This
difficult.
notification we have already annexed in our.
Yes, no, I have compiled it for the convenience of the court. Appreciate that.
Yes.
37, your lordship will find at 4, serial number 4, thalassemia. Your lordship got it?
Yes.
Then your lordship say less than 40% disability, I will not qualify for the PWD quota. But if I get unmarried, then I will get it done. Now, to eligible for medical course for PWD quota, I have to fall within the benchmark of 40 to 80% disability. And more than 80%, I'm not eligible.
Oh.
You'll also see one more thing. This Supreme Court, while looking into that Omkar judgment, in one of the paragraphs, this Honorable Supreme Court has said that because in terms of that notification, you should have included in the bulletin itself that for thalassemia, less than 40% you will not get it, 40 to 80% you will get it, and you have to do all this has to be mentioned in the bulletin in terms of that notification of April. But this time they have missed the bus, so I expect that they will do it from the next batch, because in so far Assam is concerned, till the other day, last year also my friend will appreciate that in case of OBC quota, till the last year, they were given admission even to the creamy layer, whereas that Indrasoni's case came in 1995. If to understand that concept of creamy layer, non-creamy layer in the medical admission, and creamy layer students were getting admission till last year only when we moved the case before the Honorable Division Bench. Now they have modified it and said that that now it will not include the creamy layer in the OBC category. So here also, my lord, these are the cases where we throw light that only the deserving candidates get it. In terms of the certificate, I can go and appear before the AIMS medical board or wherever your lordships direct. But here, this is a clear-cut case where I've got my certification as thalassemia intermediate stroke major. And once I'm intermediate and major, in terms of this gazette notification, these guidelines which the central government has notified of 2024, if I have a thalassemia major or intermediate, I will be entitled to that 40% benchmark disability. So for Omkar's case is a little bit different. In Omkar's case, what has happened? In case of locomotor disability, in that case of disability, they have confined it to only 40%.
No,
Then,
see, not that I've seen.
Yes.
I've seen the diagnosis of the AIMS,
Yes.
Guwahati,
and include Gangaram.
both.
Yes.
Take this report.
Yes.
Go before the
They will give
AIMS
them-
authority.
But your lordship
No,
will
give them a certificate.
Yes.
That you have, let them give you a certificate. That
They
you
will
have,
give me as an intermediate or major only. They can't
That's
give me,
all.
yes. Because then under the guidelines,
this code is not saying that they
sure.
should give you 40.
That
Then
because,
they will go according to the
Gaia,
notification.
yes,
That's
and I
all.
can show it also, because in case of locomotor disability also what has happened in most of the cases I have seen, in this guidelines of 2024, they have to do certain tests of the locomotor disability. I don't know why this time Assam government has not done those tests, and only on the visual examination, they have certified that this person will fall under 14%. If you say a particular person that he have a 14% locomotor disability, can my learned friend produce any of the documentary or the contemporaneous record to show how this 14% has been calculated? That is not there. They only in the affidavit, they said that it is 14%. That's why your benchmark disability is below 14%. Because you have to take the weight, size, measurement, lots of parameters are given. They are ignorant of this guidelines of 2024. That's why all this difficulty has arisen. And students who have to pursue study is now running from court to court to get some relief from your lordships, madam.
Then we'll pass a command
Yeah,
order in
command
order.
order. That's
Your
what I'm
lordship,
saying, my lord.
ask them to give the report if it's possible.
My lord, Mr. Sodri is here, my lord. He will be the last person, my lord. Sir, direction, please.
You go.
In fact, they can. Should we fix a date for their appearance before the competent?
And the aim should constitute a board, because in a,
That I will take care.
no, your lordship will indicate that they will constitute a board in where there is a hematologist, or for locomotor disabilities, they will have orthopedic department.
They will consider a board
Ah.
in terms of the specified disabilities.
No, my lord, lordship will have to indicate that in the order itself. Only then they can,
Yes.
before then they can constitute a board. Because
No,
moment
that's
that-
why I'm saying in the order, I'm going to say that
Lordship,
this court cannot say you constitute this
On
board
that,
for this
yeah,
one,
yeah.
this board for this
But
one.
so far I
Or
felt
if they
that
will depart, lordship will mention, they will.
yes.
Consisting of all specialists
Yes.
for examining the specified disabilities of the concerned petitioners.
Yes.
My lord.
And after,
No, lordship will indicate the disability of the petitioner. Only they can, then only they can constitute.
Uh-huh.
Otherwise, on that day, very day, it will be difficult to constitute it. my lord.
Because only that they, in case of mine, so far item 71, they have to hematology.
it will be a common order, but then for you, there will be a separate
Yes, yes.
paragraph.
Yes.
May I suggest, my lord,
Mm.
one point? My lord, because my lord, there is already PWD certificate, taking into consideration the PWD certificate, and by applying, my lord, 2019 notification appendix H1, my lord,
No, no,
if
you
this
will
medical
have to say
examination is
independent
conducted,
examination, not relying
my lord,
upon
then it
independent.
will be proper, my lord, and as per law, my lord.
No,
That is, that is.
the process for how it has to be done is indicated in the
We want independent
2024.
verification.
We'll
from a
produce all the
computer.
records before the AIMS authority, my lord. Because now examination is not that the AIMS can also do it on their own. They will be guided by the 2024 notification, how they have to do that. That is detailed, because Supreme Court has said that you earlier did not have the guidelines. In terms of the Supreme Court direction, only these guidelines have been, 2024 guidelines have come, which has laid down the procedure how to conduct the test in respect of each of the disabilities. Now they cannot say that the AIMS will devise their own procedure. That is not the.
We are, nobody is saying that.
2019 notification should be the benchmark, my lord. 2019.
That is in H1, but so far the procedure
H1.
to examine the locomotor or thalassemia or other, that is indicated in the 2024.
They will decide.
Okay, let me pass my order. You just
My lord.
don't go. See,
My
if
lord.
I'm going wrong, you correct me.
One item, my lord, item number 75. There, my lord, I had filed an additional affidavit.
Mm.
If my lordship may, for a moment, if kindly take into note the page number 82 of my additional affidavit, annexure 1, my lord.
Give me his items only. It's 75.
My lord, this is the, my lord, information bulletin of net UG, my lord.
You file an additional affidavit.
I filed an additional affidavit, my lord. Page 31,
1 minute. Where's your additional affidavit?
page 82, my lord.
Page
82, my lordship. WPC 5161/2024.
Where's your additional affidavit?
Only
Well,
five
WPC
page,
5161
that was my
only
last one
2024.
that has been clapped with the button. At the top, I think.
Page 82.
I don't know.
Additional affidavit.
Here's a rejoinder affidavit.
Page 77.
Yes, 82.
82, my lord.
Hmm.
A small affidavit, my lord.
Hmm.
The certificate of disability for NEET admissions.
Hmm.
As per MCI gazetted notification number so and so dated so and so 14 May 2019 for admission to medical courses in all India quota.
All India quota.
Remark, my lord. With use of advanced low vision, 8% of disability falls below 40%. And this is, my lord, this certificate has been, my lord, issued in terms of, my lord, page 31. I just placed before your lordship the bulletin, information bulletin of NEET UG, my lord. There are 16 numbers of institutes who have been enlisted, including AIMS, my lord. who can issue, my lord, direct certificates, my lord. Ascertaining, my lord, 2000, following 2019, whether the PWD, my lord, percentage, the benchmark disability falls below.
This is issued by which authority?
Issued, my lord, my lordship will find at page 99 of this bulletin, my lord. This bulletin, my lord, page 99. Page 99 is
This one.
my lordship. The respondent have relying on page 99, my lord, appendix 7. These are the list of disabled certification centers who will issue disability certificates as per NMC norms to PWBD candidates in support of their claim to avail 5%, so and so, my lord. Then next page, my lord, 100. Serial number 11 is the, my lord, institute who has issued this certificate, my lord.
Anyway, we are directing
There's no
the.
dispute, my lord. We have found it 0. They say it is 40. So to
This
if
is, my
raised
lord,
to this dispute, my lord, will have to appear before the court, facing
from
court.
their institution, my lord, it has been issued.
Not by us, my lord. Not
And
for
from
for the
the
state
net
quota
use
seat,
the-
my lord, is a different, my lord.
Okay, heard Mr. B.D. Gonwar, senior counsel. Assisted by Mr. B. Dolloy. P. Dolloy, learned counsel for the petition. In WBC number 4793 oblique 2020. And WBC 5173 oblique 2024. And Mr. M.K. Das, learned counsel for the petitioners in the other writ petitions. Stop. Also heard Mr. B. Gogoi, learned standing counsel, health department. Any others appearing?
No, my lord. Here, in one case, my lord, NMC was there. The Poitier appeared.
Anyway, and Mr. Gogoi, you're not appearing.
In item number 77, NMC.
Yes. Mr. R.K.D. Chowdhury, learned Deputy Solicitor General of India for the.
We are not made a party.
You are not the
It's not a
member.
party. Lordship will leave this on the request of the court, my lord. He will-
And Mr. Appears for and on request, huh? And on request made by this court, Mr. R.K.D. Chowdhury, learned Deputy Solicitor General of India, appears for the All India Institute of Medical Sciences within bracket AIMS, Guwahati. Guwahati. Stop. Para. The petitioner in WBC number 5077 of cancel it. All the petitioners in this batch of writ petitions are intending candidates for admission to the MBBS oblique BDS.
Yes.
MBBS.
All
oblique-
MBBS, otherwise they are aspiring to MBBS, medical court.
Okay, aspiring for the post of MBBS, for a seat in the MBBS course under the Assam
State
quota.
quota, yes,
Under
state quota
the
seats.
Assam state quota for the academic session 2024-2025 under the category of persons with disability. Under the category of persons with disabilities, under the rights of persons with disability, under the rights of disability with specified disabilities, under the rights of persons with disability Acts 2016. 16. Stop. They are all aggrieved. They all have the disability certificate issued by the competent authority. However, they are aggrieved due to non-selection in terms, in view of the medical report.
They have scaled down my benchmark disability. I am aggrieved because they have scaled
In
down.
view of the,
Scaling down.
the scaling down of their benchmark disability by the, what board is it? By the medical board?
Yes,
Medical board or medical
Medical
assessment?
Medical assessment board
By the
constituted
medical
pursuant to
board
the
oblique assessment board
Okay.
constituted by the Directorate of
Director of Medical Education.
Directorate of by the Director of Medical Education.
Assam.
Assam. Stop. Para. The petitioner in WBC number 5077 of 2024 is having a disability certificate. Where is that certificate? Is having a disability certificate. Is having a 40% disability, permanent disability certificate. In relation to her both eyes. And she is a case of low vision. Issued by the competent authority. Stop. The petitioner applied. I'm not going on all this or not. The petitioner is aggrieved. Where is that scaling down?
It's in the affidavit. Not this one, my lord, not scaled down. 40.
Okay. The petitioner is aggrieved for non-selection,
My lord.
despite having a 40% disability in the MBBS, for a seat in the MBBS course. Stop.
Because my lord, without using my lord,
The petitioner in WBC number 4793 of 2024 is having a 40% permanent disability certificate
of thalassemia intermedia,
of thalassemia intermedia,
gene type
comma,
B positive,
gene type dash B plus oblique
B plus,
B
beta plus.
Stop. Where's your rejection?
Page 61, my lord. Affidavit. The disability board came to a finding that the disability of the petitioner is below 40%. Page
My lord, one
61.
document will, my lord, suffice, my lord. There is a chart, my lord, which, my lord, the results were finally given. In the case of item 71, if your lordship is looking at, that lordship will find page 78.
Page
87.
Page 87, yes, my lord. CL number 16.
Page 87.
Yes, 87. Last one, my lord. Age
All these are petitioners before this court.
My lord, in fact, my lord, entire chart, my lord, which is relevant to this particular case, that we have annexed, my lord, in WPC 5161 and other cases. That lordship will say, my lord, the lordship will see, my lord, page 5161, my lord, the WPC first case.
Yes.
5161, my lord, 115, page 115. One one five, this is the covering, my lord. Lordship will see, my lord.
কোনকেইটা petition আছে এইটো item number 71 মানে serial number 16 is item number 71
My page on my lord 116 onward. Page 116 onward. These are the, my lord, this is the chart, my lord. In the remarks column or the board's comment, my lord, everything is there. They can indicate the, my lord, serial numbers. my
yes
lord.
but again 16 I am item number 71 and again serial number 3 I am item number 77
Yes, Amit Gupta.
Amit Gupta is 77 item number 77 serial number 3 and 16 is
Apsana Begum to okay.
Serial number 60
One
is, my
minute,
lord, item
one
number.
minute. The petitioner in WBC number 5152 of 2024. What is your case? 5152 is that?
নামটো কৈ দিয়া
Hang on.
এটা কি disability 5161 my lord
5152.
নামটো কি
আপনার হেতু কি আপনি রকমই তো
নহয় serial number 8 মানো page 11
Is a candidate. Which your disability certificate?
Scale down to my lord.
No,
30.
no, no. Disability.
disability certificate to করো
Disability certificate. Type to my lord. Medical examiner. Page 25, my lord. 29, my lord.
40% permanent disability
Scale down to my lord.
in relation to his both eyes. And is a case of low vision. I'm just putting that
My
much
lord.
to rest.
serial number টা করিস না costly to cycle কুটি দিও
The petitioner number,
সাকুল
petitioner in WBC 5518 of 2024
নামটা কি আছে
My lord.
is having a
50%.
permanent disability.
Page 28, my lord. 50% locomotor.
5158.
5158.
WBC 515.
Page
28, my lord. Disability certificate. 50% locomotor. Page 28. my lord.
is having a 50% permanent disability. And is a case of, is having a 50% permanent disability. Is having a 50%
Locomotor.
locomotor permanent disability.
My lord.
The petitioner number in 5159 only 2024. What is your
Page
case?
28, my lord.
No, what is your case?
40% locomotor, my lord. Page
Is
28.
having permanent,
Permanent.
is having 40% locomotor permanent disability. Stop. Petitioner number in WBC 5161 oblique 2024. What is your case?
5161. 5161, my lord. Huh? 5161. Aksana. My lord, 29, my lord. 40% disability, both eyes. 5161, my lord.
60.
Aksana. Page 29.
is having 40% low vision permanent disability, correct?
My lord,
40%
40% low vision, my lord.
low vision permanent disability.
Nadia,
Issued by the competent authority.
In this case only, my lord, one certificate has been issued by one of the institutions, my lord.
That I'm not going.
My lord.
The petition in WBC 5162. Here what?
Forty percent disability of both.
Is having 40% low vision permanent disability.
Page 20.
Issued by the competent authority. The petition in WBC 5173.
5173 is locomotor disability, brother.
Where is that?
Page 35.
Is having
Locomotor disability of 40% bench part disability.
40% locomotor disability. And the petitioner in WBC number 5274 is having who is the petitioner's counsel?
My lord.
5274.
That is not my lord related to this.
My lord.
Ah, he's
That is
here.
separate. No, that's my lord, that's 5% quota. Though it has been clubbed, my lord, it's not relating to disabled category.
Is it?
Yes, ma'am. Aminul Islam is different, ma'am.
Okay.
Till my lord, it will be till only
Okay.
77.
Okay.
Total 7 cases.
Where's that common list?
Well,
That common list?
my lord, 5152.
51?
52.
Ah.
Lordship will see, my lord, page 117.
Yes.
By this letter, my lord, the entire medical examination reports were submitted in a tabular form. It is on 5924, the chart at page 118.
Amit Gupta question, item number.
77. Lordship will see the page 118.
1 minute.
Amit Gupta
7. 5176. One one seven is the covering letter, and 118 the chart is there.
SL8, serial number 8.
My lord will see serial number 3 is my lord item 77. Amit Gupta.
All the writ petitioners. No, stop. The principal cum chief superintendent, Guwahati Medical College and Hospital, by a communication dated 5/9/2024, addressed to the Director of Medical Education, Assam, submitted the medical examination reports of the candidates who appeared before the medical board. Stop. In the in the set list, the names of all the petitioners appears, and the comments of the board are shown against each of the names of the petitioners. That much only I'll do.
Yes, Lordship may indicate the serial number. Serial number
It will be-
316.
It will be difficult to,
No, only mentioning that their name appears as serial number so and so in that list.
okay,
In this series, madam.
the petitioner and WBC number,
Oh, that
that is what I'm saying, so that's why I'm
It
giving,
is WPC number, madam.
if I give all this,
Yes, it
again,
will
we'll
be
have
true.
to go back.
Madam.
So I'm saying all the,
Yes, yes, yes.
and the names and the comments of the board, medical board are indicated against each of the names. Stop. The petitioners are being aggrieved in as much as the medical board scaled down their disabilities and the petitioners are being deprived of getting a seat for for admission into the MBBS course under the different medical colleges under the in the state of Assam. Stop.
This notification, my lord, that has been placed by the respondent side, my lord. 2019 notification, appendix H1, my lord. That, my lord, one line may kindly
Yeah,
be
that I'm putting. Where is that? Which in which petition?
in five one,
Compilation is
Yes,
there?
in that compilation.
Compilation, it is at page 34.
Board of Governors, my lord. It's
Page 34 in
2019.
the compilation. Two notification at page 34, that is,
H1 is required.
yes,
H1 is
H1 will be
2019
applicable.
notification.
yes. H1 is at page 35.
The Board of Governors of the Medical Council of India issued an amendment notification dated 13th May 2019. It will be a new paragraph. Huh?
Your lordship will indicate the SO number of that gazette notification. Yeah, that number MCI, I'll place that gazette notification, but your page 34,
Issued
that
an amendment notification number
MCI dash 34.
MCI dash 34 within bracket 41 oblique 2019 dash MED stop oblique 112862.
Well, sufficient. And the latest notification at page 50.
1 minute.
Appendix 8.
1 minute. Wherein?
Page 35, appendix H1.
Dated 13 July 2019.
13 May, man.
Amending the Graduate Medical Education Regulation 1997 by the Graduate Medical Education Regulations Amendment 2019. Stop. In the said notification, the guidelines regarding admission of students with specified disabilities under the Rights of Persons with Disabilities Act 2016 with respect to admission in MBBS course is defined in appendix H-1.
Your lordship will
Stop.
also, your lordship will also refer to page 50. This is the guidelines for the purpose of assessing the extent of specified disability. This will also be applicable, page 50.
Further, the Ministry of Social Justice and Empowerment by notification number S stop O stop 1138 within bracket E notified the guidelines for the purpose of assessing the extent of following specific of extent of specified disabilities in a person after in a person. Stop. Para all the writ petitioners before this court are not satisfied with the report of the medical board constituted by the Director of Medical Education, and therefore have filed the aforesaid writ petitions, praying for direction to permit them to be admitted into the medical colleges under the disability, in terms of the disabilities in the different colleges, in terms of the reservations of their disabilities made in the different colleges in the state of Assam, in the different medical colleges in the state of Assam. Stop. Now, what was the other thing?
My lord, item 75 and 76, my lord.
1 minute. The learned counsel for the for the petitioners has referred to a judgment dated
15th of October.
15th October 2024, passed by the Honorable Supreme Court in the case of Omkar Ramchandra Gon versus the Union of India and others, within bracket, civil appeal number 10611 of 2024, and contains that in similar matters, the Honorable Supreme Court has
taken the view of independent medical board.
Has taken the view of taking the opinion of an independent body with regard to the specified disabilities of such persons. Stop. Stop. They therefore contend that their cases may also be referred to an independent body in the independent body for assessing their disabilities in the state of Assam. Stop. In fact, the learned counsel for the parties has no, don't say like this. Stop. Para. That much will do.
Yeah, your lordship, directly.
Mr. B. Gogoi, learned standing counsel health department, has no objections and welcomes the suggestion made by the learned counsel appearing for the petitioners. Stop. Para. Accordingly, this court has requested Mr. R.K.D. Chowdhury, learned Deputy Solicitor General of India, as to whether the All India Institute of Medical Science, within bracket AIMS, Guwahati, can consider the case of the can examine the case of the petitioners to assess their disability in terms of the certificates issued to each of them by the competent authority. Stop. He accordingly submits that the AIMS has all the specialties required to have an assessment with regard to the disabilities in respect of each of the petitioners with regard to their specified disabilities. Stop. Para. Accordingly, comma. No. Para. Insofar as the petitioner in WBC number
The more WBC today.
4793 of 2024, does that
Yes, ma'am.
Thalassemia, isn't it?
Yes.
Is concerned. She has subjected herself before the concerned specialist,
Hematology Department of All India Institute of Medical.
i.e. the hematology department of All India Institute of Medical Sciences, Guwahati. And a diagnosis report has also been annexed in the additional affidavit filed by the petition.
And also I have annexed the report of the
As well as the report
of Sir Gangaram Hospital, Delhi.
of the Sir Kangaram Hospital, New Delhi. Delhi, it is not New Delhi, Delhi. Stop. Accordingly, comma, accordingly, comma, the authorities in the All India Medical Institute of Sciences, Guwahati, is directed to constitute a medical board consisting of specialists to look into the disabilities as regards the petitioners, and thereafter give its report. You'll submit the report before this court?
Lordship, let it be sent to the DME directly.
No, before this court, why?
I will definitely submit it before this court.
It will be easier, my lord. Going there again, they will not send, it will waste time, my lord. They will come and.
Let it be on 4th, my lord. The
Submit
first item Lordship will take
its
it.
report before this court as regard the disability, percentage of each of the petitioners.
The only thing.
The authorities in the All India Medical Sciences, Guwahati, is also permitted to send such report to the Director of Medical Education, isn't it?
Medical education.
Medical Education, Assam. Stop. Para. Insofar as the petitioner in WBC number, 4793/2024 has already subjected herself before the hematology department under the AIIMS Guwahati, comma, the concerned authority shall provide a certificate in respect of the said petitioner with regard to
Percentage of disability.
No, percentage,
that they cannot.
That cannot.
No, the medical board will do, my lord.
No, cannot.
Lordship has already considered it. The board can. Because he has a certificate issued by the district authorities.
No, cannot. The guideline says it is either it is.
Guideline says
So that's why it is 40%, they will record 40%.
They will record only whether it is intermediate or major.
No.
I am going by the guideline, my lord. Your lordship will not listen to you. Your lordship has seen the guideline. It is only if I am intermediate or major.
The act says, my lord, there will have to be some percentage. Will have to be
No,
mentioned in
they
the
cannot
certificate.
see the guidelines. Have
The
you seen the
guidelines regarding assessment of disability.
Ah.
They will mention yes, it is 40%.
No, they cannot. They will only say whether
Because,
it is
my lord, their
intermediate or
certificate is
major. my
already
lord.
there, issued by the statutory authority. How then that was issued? Indicating 40%.
Okay, then cancel that line. Stop. The medical board constituted by the authorities of
They
the
will indicate the disability.
of
percentage.
the
No,
of
yes,
the
Ganesh bhai,
All India Institute of Medical Sciences, Guwahati, shall strictly proceed
in terms of
in
the
terms
guidelines.
in terms of the notification, in terms of the amendment notification dated
13 May 2019. 13 May 2019.
page
Gazette notification for then. Put
13 May 2019. 13 May 2019.
And as well as the gazette
where's
notification
that
of 20,
notification?
page 48, my lord. 50 is the notification, page 50, in case of LSPR.
Strictly in terms of the, no,
The other one, my lord.
other one.
Other one.
H1.
13/5/2019, appendix H1, my lord.
Page 34.
In terms of the amendment notification dated 13th May 2019,
Appendix.
Within bracket appendix H1.
within bracket appendix H-1,
And the notification
and
dated
the notification dated
12 March
12
2024.
2024.
It will suffice the purpose.
My only thing, my lord, one.
When should you fix a date?
It will, of course, it will be on, my lord. On day after tomorrow, they will appear.
Okay.
And on 4th, lordship will, my lord, peruse the reports and pass up it.
The petitioners shall appear before the medical board.
Only thing is that some are outstation candidates. I'm in Guwahati, I have no problem.
Shall, what is this? The petitioners shall appear before the medical board constituted by the authorities of the All India Medical Sciences. Guwahati.
Tomorrow at
On-
2 o'clock.
Tomorrow, my lord, one
Then
of my
day after
candidates.
tomorrow it will be better.
Silchar, she's from
No, my lord.
Silchar, my lord.
No, my lord, then there is a holiday, long holiday from Thursday, Friday. We'll appear by tomorrow before 2 o'clock.
Wednesday, my lord, my case, one
Only
girl, she
one.
comes from, my lord, Silchar, my
So
lord.
one you keep it for when
So
you
that-
do it, the others why you block it?
There is some constraint tomorrow, Lordship, as I have some. Let it be day after tomorrow, let them appear.
On 30 October 2024 at 10 a.m.
11.
from 11 a.m. onwards.
11 amounts.
Is the matter
They will report
again on 4th.
Report before a particular officer, Lordship, or the dean of the registrar, they will appear before the registrar.
Okay, shall so and so from 11 a.m. onwards before the register of the AIMS Guwahati.
The only thing, my lord, that view, whatever they give, my lord, it will have to be an independent view. Otherwise, there is no purpose of sending to a, my lord, board.
That's
They
why I'm
give a-
saying.
No, independent view, lordship is not indicated.
Okay.
It's not about, my lord, our report or the report given by the statutory authority. They will give the independent view.
On top, the medical board, after examining the.
Your lordship said independent authority.
No,
No, independent
after,
view, my lord. That is the
after
requirement.
examining
As
the,
per Supreme Court.
all the petitioners concerned shall give its independent view
Independent view.
with regard to their disabilities.
Lordship, I'm obliged.
List on.
Lordship will say
No,
percentage of disabilities because
No,
of the
percentage, was- so
Otherwise, how,
2019
my lord?
notification, my lord.
It's all
Without
indicated.
percentage, my lord, how it can be assigned?
That's why your
These
lordship
are,
has amended
we are
2019
just, there's no point of shouting here.
Yes, my lord.
These are all specialists. They know what they're going
Yes,
to
yes,
do.
yes. And we will produce the
No,
2019 certificate and the 2024 notification.
I
We
can,
assist them, my lord. We will not have problem.
with all relevant documents, my lord, will be present, my lord.
The petitioners are given the liberty to produce the notification dated 2019 as well as to the 20.
And our certificate.
Before this.
And all other relevant
And
documents.
all other relevant
My
documents
lord.
before the medical board concerned.
My lord, only page, item 75 and 76, my lord. There is no interim, though, my lord, one has been granted allotment of Nagaon, my lord, one seat at Nagaon, page number 75, my lord. Item number
There's
75.
no point now. There's no point now.
Lordship,
My lord, may I pray for, my lord, at least, my lord, subject to the outcome of the writ petition, at least, my lord. Entire, my lord, process will go futile, my lord, if that limited observation is not given for these
The
two
matter,
girls, my lord.
the period has been extended to 5th of November.
That is why, my
So
lord,
we'll take care of that. We'll take
entire,
care of that.
my lord, the petitioner's case, my lord, both the girls, my lord, will entirely, my lord, go futile if this limited observation is not made, my lord. Because case has been fixed on 4th, my lord, and from 5th it will continue, my lord. Limited prayer, my lord, subject to the, because, my lord, if no college would have had been allotted, my lord, I would not have been prayed, my lord. But college, my lord, item 75, Nagaon Medical College, one seat is allotted. And item number 76, one Dhubri College, Medical College, one seat is allotted. I'm just, my lord, making a prayer for my
No, my
legitimate
lord,
rights.
today, without there being a vacancy, I don't know, my lord, how can we, my lord, even implement the court's order, my lord, if supposingly there is a
So-
vacancy. That's why. While wherever interim is there, that will be extended, and on court, my lord, if seat entitled,
That is,
he will have to be given a seat. by
from
the
the very inception, my lord, that is why I was,
Till the next date.
I was praying, my lord.
Lordship, I only.
That is why, my lord.
Or if it is
Subject to
uploaded.
outcome, one seat.
I don't know if it will
One-
be uploaded
My lord,
today or tomorrow morning, because again, after this,
My lord,
I have some work.
one seat, my lord, in the Nagaon
Very difficult for-
College, my lord.
No, what
subject to
type
the
of
out-
an order do you want?
My lord, I'm praying for the seat which was allotted to me, my lord, to be kept vacant, my lord, till the entire process goes, my lord. Or my
Now,
lord,
by
in
now,
alternative,
probably it may have been, my lord, allotted to someone. But he may at best indicate.
And then,
that it
my
is
lord-
Subject to outcome, even if it is allotted.
because it was allotted, my lord.
Any admission to the seats, to the MBBS seat? In the,
In item number 75, my lord,
I'm not.
The
In
case
the-
case number, my lord, WPC 5161. 5161
In WBC 5161,
and 5162, my lord.
2024. And 51?
62/2024.
2024. Under the disabilities quota, isn't
My
that?
lord,
Yes,
my lord.
Shall be subject to the outcome of this.
I'm highly aware, deeply aware.
May I please, your lord.
Ah,
My lord, one prayer, my lord. Let all the motion matters be listed on Wednesday.
Yes, ma'am.
Because we are,
Wednesday will be difficult,
all the motion matters, my
It'll
lord.
be very difficult. Tomorrow.
Tomorrow, Lord.
Tomorrow, ma'am. My item was supposed to be disposed of,
Tomorrow,
my lord, by today itself.
Tomorrow, Lordship.
Item 68 is there, my lord. In the supplementary, my lord, motion, my lord.
Tomorrow,
Only
Lordship.
the leftover item is only item 68. my lord.
All motion.
That was supposed to be disposed of, motion item, my lord.
What matter is this?
That is regarding, my lord, the SMC, my lord, president of SMC, my lord, which was taken up on last Friday, my lord.
Hmm.
That matter, my lord. Lordship was supposed to dispose of by today itself, my lord.
Mine is item number 2 is a contempt, just the notice to be issued. That's all, nothing else. Mine is 3, Lordship, contempt.
By tomorrow, my lord.
All matters tomorrow, Lordship.
Tomorrow.
All motion matters.
Motion matters.
Maybe tomorrow.
How do I pass? Can you tell the real estate, the motion makers will be listed tomorrow, or there has to be a judicial order? Okay, do one thing. Due to paucity of time, this case cannot be taken up today. From item 2, huh?
Yes, Lordship.
Item, I'll just take down, list the matter. You give tomorrow's date. That will be item 2, 3, 4, 5, 6, 7 and 8 is adjourned. 9 to 14 and 16
And item 68 in supplementary motion.
and item 68.
68.
79 supplementary list, Lordship. Motion, Lordship.
Okay, 79.
My lord, item number
79.
5, my lord, it will come on fourth, my lord. Item number 5.
That will come up. Which item?
Oblige.
Motion.
Motion, item number 5, my lord.
Is it tomorrow? Tomorrow.
Tomorrow.
Item number 5, what do you want?
On fourth, my lord.
You don't want it tomorrow.
No, my.
List on 4. Item 5.
Much obliged.
Much obliged.
Thank you.